Good morning.
Mr Birnbaum, before we resume your submissions,
Yes.
we need assistance from you and Mr Price on another matter relating to reporting. We considered this yesterday. I've received an email from a gentleman who is running the recording for television purposes. I'm very grateful to him for that email. He helpfully reminds me that the protocol which governs such recordings imposes additional constraints on what may be broadcast when, and in particular prohibits any broadcasting of anything that was recorded yesterday or will be recorded today until any question of a retrial has been ruled out. Now, the submissions you made yesterday, Mr Price, did not rule out any question of a retrial. Is there anything you want to add to what you said yesterday?
No, my lord, it remains the case that the respondent has identified a route that the court could follow that could lead to that consequence. I'm happy to spell out what it is if your lordship asks me to do so, but it remains my view that it exists.
Yes. Well, I'm not sure it will help us to ask you to spell it out, because, of course, all this is hypothesis upon hypothesis as to what the ultimate outcome may be. But your position remains as it was yesterday.
It does, my lord.
Yes. Birnbaum,
May I say just this very briefly? Bearing in mind that Oliver was released from prison, I think, in 2002, and that Eric Samuels, who one would hope would have been able to give evidence at any retrial, died in 2014. For my part, I cannot foresee any circumstances in which there would be a retrial. That's all I say.
Yeah. I'll just inquire whether those involved in the recording for this purpose themselves wish to say anything on the topic.
No, thank you, my lord. And,
Just want clarification.
indeed.
Well, thank you very much for raising it. I think we'll just rise just for 2 minutes to consider our decision on this. We're grateful to all those who've assisted us on this short but important point. We emphasise again that anything we say about possible outcomes of this appeal are no more than hypotheses about what in law are the various possibilities. But it seems to us that as a matter of law, one possibility which cannot at this stage be excluded is an outcome of the appeal which results in a retrial. Mr Price has made clear very helpfully that the prosecution are not prepared at this stage to say they will never seek a retrial, that there's nothing wrong or improper in that attitude being taken at this stage. So I think we have to say that the possibility of a retrial cannot here and now be excluded. That has consequences for what may or more particularly may not be broadcast. And I'm afraid that those are the consequences. Thank you very much. Yes, now Mr Birnbaum.
Lord, we have been giving some thought, our team, overnight,
Yes.
to how we can use the time. A day for the rest of this case is maybe at least a pint and a half in a pint pot. But I think we can manage it in this way. And may I make this suggestion? I will, in a few moments, take you through the rest of the Samuel schedule. Then we will call the two expert witnesses, Professor Johnson and Dr. Beck. It seems to me, if I may say so, that there are three things that the court will want to do, at least today. One is to hear that evidence. Secondly, I'm sure you will want to hear from my learned friend Miss Slowe, who estimates her submissions at 20 to 25 minutes. You will, of course, want to hear from a learned friend for the respondents, who estimates his at 90 minutes. We don't quite know how long the expert evidence will take, because you may well have questions or seek clarification, and the reports are very long. So what I'm going to suggest to the court is this, that I will keep the situation under review during the course of the day. I may well say to you, say early this afternoon, here are the rest of the matters that I would like you to consider, and here are the page numbers in my argument. I would like to have the opportunity, after a learned friend has made his submissions for the respondents, to be able to address you at least briefly on the headlines of my own submissions. And if your lordships would like, if the court would like more than the headlines, then of course I could submit a document after the court has risen. So I hope that that is a practical and helpful suggestion as to how we might proceed.
Thank you. I don't understand what you mean by headlines of your main submissions after Mr. Price has...
Well, suppose we only have 15 minutes at the end of the day, and I will, well, 10 minutes. I could at least take you, I could at least tell you how I put each ground. You may want to hear from me on that.
I'm sorry, Mr. Birnbaum, the time to do that is during your submission.
Very well, I'll do it then.
When Mr. Price has made his submissions, if there are matters arising from his submissions to which you wish to reply, then of course you may.
Yes. Well, yes.
You can't, as it were, come back and have a second go.
No, sorry. I misspoke. I was going to take a little time before Mr. Price spoke, to outline my submissions. I'm going to do that.
All right, thank you.
So, my Lord, can I take you back to the schedule? You
have to remind us of the page reference, please.
It's CACD 1, page 2128 to 2132.
Thank you very much.
Well, I should have referred you to serial 17, because yesterday I took you through Sanderson's.
Do pause, please, Mr.
Yes,
Birnbaum.
I'm sorry.
Serial 17 is on CACD 1, 2131.
Right.
Does the court have that?
Yes.
Thank you.
Yeah. Yes.
I should take you briefly to serial 17, which is the letter undated that Sanderson wrote to Sculthorpe. I'll just read this. Sanderson, having expressed concern that he'd been identified as a murderer serving a sentence at a particular prison, a sex offenders prison, wrote an undated letter. He'd been thinking about his own position. He wanted to help Oliver, but did not want to make long-lasting problems for myself. He did not want his statement to be used in a BBC program. I have to say, I can no longer be certain whether Eric did in fact say what I thought he had said. Well, if his statement stood alone as evidence of exculpations of Oliver, then it might be that the court would have considerable reservations about it. But it doesn't. And it cannot be a coincidence that, for example, what he had to say about Samuels's attitude at the time of his plea and the trial was so similar to what the anonymous informant had to say in the letter that I read out to you yesterday. And in fact, as I read my learned friend's submissions, he doesn't seek to say that Sanderson can be disregarded as someone who made it up, but he will correct me if I'm wrong about that. So yesterday, I took you to the situation with Mr. Burton, the solicitor. I took you to the correspondence between Eric and Oliver, and now we come to what I suggest is one of the most interesting documents in the case. At serial 20, on the 28th of October of 2001, the covert video recording of Eric speaking to Linda Cowell, a BBC journalist. Now, my learned friend will give you the reference to that.
The transcript of that recording is available at the court's K1, page 71 to 78. There's also a hyperlink in the schedule to take the court there.
Thank you very much.
Working, unfortunately. Are you able to work your magic, Miss Slow, and conjure it up on our screens, because the hyperlink isn't working for me? It may be purely personal refusal to cooperate with me.
You should now be receiving an invitation.
Alas, not so far. I'll find it elsewhere in the system.
I have to say that for me, this is an education in how this system works, or does not work.
No one would have guessed, Mr. Birnbaum.
If it assists my lord, it's at tab K114.
Thank you. I'm getting there very slowly. Right, thank you.
Yes. So this, of course, is a verbatim recording, save where there are indications that it was not audible. We've spoken to Lucia, says Miss Cowell. I don't know who Lucia was. And we got the impression that you wanted to speak to us. We're pleased that you agreed to see us. We're interested in what you've got to say. Eric says, well, I made a statement to my solicitors already, and I want to hear from Oliver first. Interviewer, the only problem with that is that his solicitors are rightly concerned about what it is that you've got to say. We just don't know. And then, I want to speak to him. I class Oliver still as a friend. I should have got in contact with him, though. I should have seen where he was, but I don't know his prison number anymore. Because me and him were inside the same time, and I told him I'd write to him when he was inside. That was 9 years ago. That's basically it. Question, do you understand his solicitors might be quite cagey about you speaking to him because they don't know what I'm going to speak about? Interviewer, yeah. Can you give me any indication of what you're going to speak about? Do you think you'd speak about what happened? Answer, yes, that and all. Have you thought about him a lot? Eric, yeah, I have. I've released my statement with the solicitor. As soon as I hear from him, I'll release it. Do you come out often? Every week. I'll probably soon be out in a hostel soon, probably next year, February. What do you think you're going to do? Are you worried about coming out? Not really. I'll be glad to come out. I want to write to him, tell him my situation. Interviewer, I know this is a cheeky question, but do you think you'll ever consider talking to us? Eric, what, the BBC? Yeah, I would. Interviewer, it's just difficult because I didn't know what you would like you to say. I was just curious. Eric, if you're curious, my statement's there, presumably the statement to Mr. Burton. Like I said, I think they would just be concerned that you may or may not say what you said in your statement. Eric, it's all there. Interviewer, can you give me the gist of what you said? I'm sort of scrabbling around in the dark here. About Oliver wasn't there and things. Tell them the whole story about how the incident happened and how Oliver was connected to the incident. Sworn statement that he's not there. Wasn't there at the time. Interviewer, out of curiosity, what do you mean when you say how Oliver was connected? And Eric says, why Oliver was arrested in the first place, why he got arrested, and why, there's something inaudible, what happened for him to get arrested. Put it down to the hat, and the cap. And how all of us, there was 4 of us originally, that's the 4 perhaps mentioned to Mr. Cater, you'll remember. There was 4 of us originally, and how Oliver got his hat taken away from him. Things like that. Interviewer, do you remember it well? Yeah, of course I remember, yeah. I know you want to help. Tell the truth, that's all. The incident happened round the corner, you know. And I think he was in hospital at Homerton, so Hackney would have been round the corner. And actually, and I correct myself, this interview took place in his mother's home. So if she was still in Bannister House, the address we saw yesterday, that would have been round the corner. You must go past there quite a lot. Yeah, different management. How do you feel when you go past there? Is it weird? Yeah, I really done my bird, I really done my prison sentence for my part in attempted robbery. Another cheeky question, my producer has asked me, because in order to help Oliver, the best thing you could do is give us an interview. You say you're willing to do that, but you're quite a difficult man to get hold of. I can get hold of him. Would you be prepared to do it today? Today? Nah. Do you have any idea when you would be able to do it? A couple of weeks. Interviewer, the only problem with that is that the program we're doing, we've got about 2 weeks left, and then that will be the end of the program. I know it feels like I'm pressurizing you, but we'd like to do an interview with you before the end. Not today, no. At any point in the next 2 weeks? Yeah. I really appreciate you talking to me today. I know it's time out with your mum and stuff. Will I be able to find out if it's possible to do an interview with you? Eric, write to me or something, or ring me. Do you think you'll be out next week? Yeah, probably. I know Oliver would appreciate it. How long do you stay when you normally come? About 3 hours. Do you come for dinner? Yeah, something like that. How is it in the hospital? Boring. What do you do to pass the time? Sometimes we go up to the gym, go outside 10-pin bowling, but most of the time we stay in. What do you think you're going to do when you come out? I'll be in a hostel, hopefully emigrate from the country. I'm 41. I don't think I can do it here. Where would you go? Back to my country, Antigua. One last question, how will you react when you see Oliver again? And then this, and this is where I suggest it starts to become rather interesting and informative. We parted on a good note, and I don't think he's got anything against me. I think he knows shy now, I don't know what that means, because I said something to him before we got arrested. He told me that his hat is on the TV. This is before we got arrested in the street. And I told him, don't bother with it, don't do it, don't say nothing, and don't bother with it. He didn't take my advice. He went on to get arrested. Don't bother with it, don't say nothing. Now, pausing there, he told me his hat is on the TV. We don't know to what extent this incident was publicized by TV at the time, immediately after the robbery, but we do know of at least one program that publicized it the night after. Anyway, that's what he said. Why do you think he did, though? Is that just the way he is? That's just the way he is. Curious, curious. And when he got arrested, he said some silly things. I said, why did you say that, Ollie? Were you surprised that he said those things? Yeah, it's not even nothing to do with him. He said some things that I couldn't believe. Did you ever ask him why he said those things? Yeah, he said he don't know. Were you best mates? Did you see each other a lot? We used to talk in the street. Some woman in her statement, he kept on going back to her, and this is obviously Carla, the seller of the hat. She said she kept on seeing Ollie, and he kept on talking about the TV program. What was it called? London Tonight, and things like that, about a picture and the hat. Yeah, he just seemed to grab onto that and said, not let go. Yeah, he went to this woman and said to this woman that it was his hat on the TV. Now, this must have been about 2 weeks after the robbery, as Carla said in one of her statements, you'll remember. I told him, why did you do that stupidness? What's the matter with you? I told you before to keep quiet. What was she supposed to think? Interviewer, it's weird why he'd pick up with something and carry on. I told him before, after the incident happened. Interviewer, maybe he just didn't realize. Yeah, I just said, forget it, Ollie. I think he fancied this woman. That's why, and that's why it come out in her statement, trying to be a big shot. He doesn't come across as someone who tries to pass them off as a bad man. Eric, he's not all there, man. He's a bit backward. He don't know. He's never been arrested before. He don't know. Do you think he looked up to you because he was trying to impress people? He was trying to impress people. It was good that you didn't part on bad terms. And then this, which I suggest is very important. No, why should I? I told him in the first place, at risk to myself, something, something, something. It's not doing my case any good saying that I knew about the gun and all that. And if that was played to the jury, I'd get convicted and all. I told him the truth in the beginning, but after a while I shut up because it wasn't. If I didn't shut up, I'd get convicted and all of murder. I asked Ollie, why did you say those things? And he says he doesn't know. So question, who is him referred to twice? I suggest that it's almost certainly Detective Sergeant Cater. I told Detective Sergeant Cater in the first place at risk to myself. It's not doing my case any good saying I knew about the gun and all that. And if that was played to the jury, I'd get convicted and all. I told Detective Sergeant Cater the truth in the beginning, but after a while I shut up. I suggest that that makes perfect sense, and it explains what happened. That having told the truth to Cater, he realized at the trial that he must shut up. Otherwise, he'd get convicted if it was played to the jury. Eric, he must have thought it was a game, first of all, that the police would leave him alone and all that. In court, that he realized it's not. I don't think we can quite make sense of that in view of some words that are omitted. Will this be going to court, he asks. We're making the program to help Oliver when it comes to appeal. They'd want me in court, though, wouldn't they? I don't know. I don't think so, would you? Yeah, why not? All I can do is get them to release my statement. Well, we'll all have to get on the case about that. And then it ran out, because I think Ms. Cowell explains in her statement that she was concerned that he would realize it was being recorded. I may say that they had taken legal advice, the BBC, as to whether they should do this and whether it was a proper and lawful thing to be done. So, going on from there, and the rest of it I think is quite brief. But serial 21, and this is now the CCRC instructing independent solicitors to represent Eric, who was at that time sectioned under the Mental Health Act, as they understood it. And this is in the period December 2002 to March 2003. Two psychiatrists had indicated that Eric would like to assist. A lady called Miss Moller of Scott Moncrief suggested that the CCRC arrange an immunity from prosecution for Eric. Miss Jones of the CCRC asked for an indication of what he would say. Eric decided not to give a statement, to waive privilege or give evidence, and that's the summary of quite a lot of correspondence that we have. And then the note that comes next, that number 22, a note of the 24th of February 2003, Scott Moncrief took advice from the Law Society as to whether this matter could properly be disclosed, as you'll see from the detailed summary that we have done in our argument, and they were advised that it could be disclosed. Long discussion with CCRC. Ms. Jones, without disclosing at any point clients' instructions, so that's the point, they're not disclosing their clients' instructions, reiterated concerns about criminal justice bill and loss of auto for convict. And you may recall at that time, it was something of a hot topic as to the changes to the law of double jeopardy, which were then before Parliament. Talked in general terms about possible concern of witness about disclosing evidence against killer as opposed to person convicted. Would CCRC offer any protection? It would be helpful in deciding whether or not to make a statement, waive confidentiality, etc., to have confirmation of the CCRC's position. And the CCRC, perhaps very understandably, took the view that they could not express any view. So there we are again, expressions by Eric apparently of concerns about his own position, not only from the true perpetrator, but on this occasion, would he be further prosecuted? As for the rest, it's very brief. Serial 23, in March of 2012, Mr. Maddox, as Oliver's solicitor, met Eric and urged him to seek independent legal advice. It's believed that he did so, but from a specialist in divorce work who advised him not to get involved. Mr. Maddox received no reply to later correspondence. And then finally, in August of 2016, inquiries of Peter Burton and Bullivants revealed that the file related to Eric had been destroyed. Hence, the statement he made to Burton was no longer available. And I just explained that. We had realized by then that as a result of an amendment to the Criminal Appeal Act, it is impossible in some circumstances to ask the Commission to seek the disclosure to the Commission of what would normally be privileged material. And so we thought if the statement to Burton still existed, we might invite the Commission to exercise that power. Unfortunately, it did not exist. It had been destroyed, as they had the rest of their papers of that vintage. So that is all I seek to say about the Samuel saga. And now, if it's convenient to the court, I would like to call Professor Gudjonsson. Learned friend will give you the references to the statement I'm going to refer to, and also to the statements of Dr. Beck.
Thank you very much. Yes, Bernard.
Lord Miss Slow will address you.
Oh, right. Thank you very much. Miss Slow.
My lords, my lady, I will be making submissions in respect of ground 16 of our grounds of appeal, for which leave has already been granted, namely contemporary standards during criminal proceedings for the protection of vulnerable defendants. We submit that if Oliver came before the courts today, he would have a wholly different experience to that of his trial in 1991. Law and practice around ensuring realization of the right to a fair trial for vulnerable defendants, and specifically the right to participate in one's trial, has developed considerably over the last few decades, as the court will be well aware. I have set out in my written submissions a detailed summary of key developments, as well as a current legal framework. If it assists the court, that document is available at CACD 1, pages 2208 to 2231. In brief, protections pertaining to the treatment of vulnerable persons appearing before criminal courts were first enacted in respect of witnesses by the introduction of so-called special measures under the Youth Justice and Criminal Evidence Act 1999. Since 2005, protections have been expanded to apply to vulnerable defendants through some ad hoc statutory instruments, but mostly jurisprudence. Today, these jurisprudential developments are enshrined for the most part in Chapter 6 of the 2023 Criminal Practice Directions, General Matters, and the 2020 Criminal Procedure Rules, which are binding on advocates and the court. Paragraph 6.1.2 of the Practice Directions refers to the Advocates' Gateway Toolkits as a valuable resource, which advocates should consult and judges should refer advocates to. Drawing on the experience of a wide range of professionals, the toolkits have been created to support the identification of vulnerability in witnesses and defendants and the making of reasonable adjustments so that the justice system is fair. They represent best practice for advocates when dealing with a range of difficulties that a vulnerable witness or defendant may have. There is now specialist training available for counsel dealing with the handling of vulnerable witnesses and defendants during their evidence and the trial process more generally. As was made clear by this court in Grant Murray 2017, it would be difficult to conceive of an advocate being competent to act in a case involving young or otherwise vulnerable witnesses or defendants unless the advocate had undertaken specific training. To appear without such competence would be professional misconduct. Assisting the court to identify and appropriately respond to vulnerability is not only a specialist skill, but part of a barrister's core duties to the court in the administration of justice, as is set out in the Bar Standards Board Handbook. As such, advocates are expected to have the toolkits at the forefront of their mind during both case preparation and conduct of the trial. Similarly, the judiciary is encouraged to have recourse to the practical examples of reasonable adjustments set out in the Equal Treatment Bench Book, which is increasingly cited in judgments and by practitioners as the approach to be adopted. Applying law and practice as it currently stands, and in drawing on my experience as counsel for the Crown and Defence in a number of cases involving vulnerable witnesses and defendants, I will seek to demonstrate how today Oliver's trial would differ significantly to that which he experienced in 1991. First and foremost, would Oliver be recognised and treated as a vulnerable defendant by modern standards? Paragraph 6.1.3 of the 2023 Practice Directions states that vulnerability may arise by reason of age, but also encompasses anyone who may not be able to participate effectively if reasonable steps are not taken to adapt the court process to their specific needs. It has been established that a person can be deemed vulnerable due to a number of factors, including youth, any mental disorder or learning disability, physical disability, or the likelihood of them suffering fear or distress in giving evidence due to their own circumstances or those relating to the case. Expert advice will be necessary if there is any uncertainty about the existence, type, or impact of a person's vulnerability. Looking at the reports and information available prior to trial, there can be little room for doubt that Oliver, as he was in 1991, would have been identified as a vulnerable defendant at an early stage of proceedings were he to come before the courts today. The 21 November 1991 medical report prepared for the Central Criminal Court by Dr. Warren on behalf of HMP Feltham stated that Oliver was, and I quote, functioning at an immature and even childish level intellectually. In a letter dated 15 November 1991, consultant neurologist Dr. Legg noted that Oliver should be regarded as showing significant mental handicap due to his defective intellectual function. Similarly, in her neuropsychology report, dated 12 November 1991, Dr. Marianne Jackson stated that mentally, Oliver was rather slow, with a patchy ability to sustain concentration to the task at hand, and intellectual functioning at the borderline defective level on both the verbal and non-verbal. Oliver's vulnerabilities in a court context are also apparent in Dr. Suzanne Young's 2003 psychological report, which was prepared following extensive assessment of Oliver in March of that year, over a total period of 6.5 hours. She noted that he had significant difficulty in verbal fluency and expression, rendering it hard for him to get his meaning across, was very slow to process information, became easily distracted, lost his train of thought, and got easily confused. He also became very tired after long periods, requiring sustained concentration, and had difficulty with complex or lengthy questions. The report also stated that Oliver's deficits meant he had a significant difficulty in coping with everyday tasks and lacked the ability to acquire new skills for more complex tasks. When faced with tasks in which he lacked confidence, he would become confused. We know from the Social Services report dated 22 May 1991 that Oliver, and I quote, switched off when asked to do new tasks, rather than being prepared to try a task which he anticipated would be difficult, and needed encouragement to do any tasks. There can be little dispute that giving evidence in court is a unique and difficult task, particularly so for vulnerable persons. Today, such stark and obvious vulnerabilities would attract a range of reasonable adjustments in order to ensure effective participation at trial. Of course, in 1991, Oliver lacked all modern safeguards. We submit it is not the lack of any one special measure or reasonable adjustment in particular that renders his conviction unsafe, but rather the cumulative effect of not having had any. Applying modern standards to the instant case, and looking first at the appointment of intermediaries for vulnerable defendants on trial today, as this plays a uniquely important and specialised role in ensuring effective participation by facilitating communication. As independent, impartial, neutral officers of the court, an intermediary's primary function is to improve the quality of evidence and aid understanding between the court, the advocate, and the witness or defendant. They use their specialist skills and training, uniquely matched to the vulnerabilities of the particular individual, to help all parties adapt to that person's communication needs. The process of appointing an intermediary begins with them conducting an assessment of a defendant and producing a report. If the report finds that an intermediary is necessary to support participation, it will go on to make recommendations. Although appointment remains a matter for judicial discretion, experience of practice in the Crown Courts is that when there is a positive report, judges will not tend to go behind that. As was recently held in the case of TI v Bromley Youth Court 2020, where an intermediary is deemed necessary for the effective participation of a defendant in the trial process, their appointment is not a high hurdle to overcome. We submit that given the extent of Oliver's vulnerabilities, it is highly likely that he would be afforded the benefit of an intermediary today, if not for the duration of the trial, then certainly while he was giving evidence. How an intermediary would actually assist Oliver at trial is more speculative, as we do not have the benefit of an intermediary report from which we can ascertain the recommendations that would be put before the court. In this respect, we are assisted by a number of neuropsychological, psychological, psychiatric, medical, social services and other reports prepared following consultation with Oliver prior to trial and in the years afterwards. In a purely academic exercise, I have reviewed this material with a view to extrapolate key aspects of his vulnerability, which would inevitably feature in an intermediary report, were one to be prepared following an assessment of him. I have gone on to consider the issues that are ordinarily addressed in intermediary reports in the context of what is known about Oliver's vulnerabilities. First, attention and concentration. It is universally noted in the reports and assessments available that Oliver had severe problems in maintaining concentration. Dr. Jackson held that Oliver had a patchy ability to sustain concentration despite applying himself to tasks to the best of his ability. Professor Gisley-Johnson also concluded in 1991 that Oliver had a particular problem with tasks that required sustained concentration. It was further noted by Dr. Tunstall that Oliver had a poor memory and difficulty remembering spoken sequences or generally keeping the thread, which may be manifest as distractibility or lack of concentration. This leads me on to my second consideration: understanding and retaining verbal information. Oliver's extremely limited, short-term, auditory verbal memory and impaired ability to retain verbal information is consistently made out. In his letter of the 15th of November 1991, Dr. Legg stated that his neurological examinations had revealed Oliver's restricted immediate recall and grave defect on more complex verbal memory, noting that on sentence repetition, he performed normally with short sentences, but rapidly lost the central words in longer sentences. This finding, in turn, leads on to the next consideration: limitation in length of sentence that can be processed and complexity of questions understood. It is clear that with Oliver's impaired memory and rapid loss of central words in longer sentences, he would only have been able to properly process questions of a limited length. His inability to understand complex question types is also made out from the reports. In his 1991 report, Professor Johnson, and he repeated it in evidence today, held that Oliver had considerable difficulty in understanding questions unless they were simply phrased, when testing acquiescence. While Dr. McKeith noted Oliver's possible tendency to conceal the fact that he had not understood what was said to him or that he had become muddled. To this end, an intermediary with an in-depth understanding of Oliver's particular vulnerabilities and needs, following extensive assessment of him, would be the best placed person in a courtroom to intervene if such a situation arose. Finally, forming a narrative. Dr. Tunstall concluded from testing that Oliver had a poor ability to express himself, performing at the level of an average child aged 7 years, 5 months, when she measured his ability to express meaning in speech. While he was able to express simple and uncomplicated ideas and information satisfactorily, Dr. Tunstall established that he could not adequately convey more complex ideas and information. In light of these considerations, one would expect an intermediary report in respect of Oliver to make a number of standard recommendations to assist him understand proceedings and express himself. These could properly include using clear, concrete language, simple everyday words, avoiding long, complex, compound or tag or leading questions, signposting each topic, speaking slowly, and allowing sufficient time to process questions and formulate answers, as well as taking regular breaks and checking Oliver's understanding regularly. Having an intermediate trial would, in our submission, be of immeasurable benefit to Oliver. Their report would not just guide curtailment of cross-examination, but would also assist defence counsel in preparing how best to conduct evidence in chief. Their in-depth understanding of Oliver would render them best placed to intervene throughout proceedings if his participation was hindered in any way, and to guide the court in making all reasonable adjustments and setting ground rules in advance of trial. Ground rules hearings, a relatively recent innovation, are mandatory if an intermediary is appointed and must also always be considered in a case involving a young or otherwise vulnerable defendant. Even if there is no intermediary, it is established best practice to hold a ground rules hearing where there is a defendant with communication needs, save for in exceptional circumstances. The importance of such a hearing corresponds relative to the level of vulnerability. Ground rules hearings are held in order for the court to set the parameters for the fair treatment of vulnerable witnesses and defendants by making rules for the conduct of questioning and other directions to facilitate effective participation. They should ordinarily take place in advance of trial to ensure sufficient time for the arrangements to be implemented and advocacy prepared, but can be revisited throughout proceedings if communication difficulties arise and additional special measures or reasonable adjustments need to be considered. Given the extent of Oliver's vulnerabilities and apparent communication needs, even if an intermediary was not appointed, it is almost inconceivable that a ground rules hearing would not be held today in order to ensure his effective participation at trial. Drawing on Advocates Gateway Toolkit 1 and the accompanying checklist, which sets out a non-exhaustive suggestion of key matters which the judge and advocate should consider at the hearing, the court would no doubt discuss ground rules pertaining to the manner of questioning and duration of cross-examination, scheduled and unscheduled breaks, his need for assistance referring to and/or accessing written material, a point that I will return to in due course, use of statutory special measures such as live link, and non-legislative special arrangements like screens to avoid distraction, and possibly even whether all testimony should be adduced using modified questions and answers to help Oliver follow proceedings. We submit that it is likely that ground rules would be set in line with the intermediary recommendations that I identified as applicable to Oliver, most of which are standard practice when dealing with a comparably vulnerable person before the courts today, regardless of whether or not an intermediary is appointed. These would be binding on all parties, and it would be the judge's duty to ensure compliance with them. As such, rules and arrangements directed at a ground rules hearing would have resulted in a wholly different experience for Oliver. It is conceivable that various arrangements could have been made in advance of and during the trial to ensure that Oliver was following proceedings and not unduly intimidated, such as a pre-trial court visit, the removal of wigs and gowns, or, as I mentioned, adducing all testimony simply and at a slower pace. Nonetheless, we invite the court to focus on the experience Oliver had giving evidence in his own defense in 1991, as this is where we submit that modern safeguards on the standards of fairness would make the starkest difference in ensuring his right to participate in his trial. First, the nature of questions. It is now standard practice that cross-examination of comparably vulnerable persons will be conducted in the modified manner I have already outlined in respect of language, question type, and pace. It is impossible to ascertain from the trial notes the type or pace of questions asked in cross-examination. One can only assume it was in the adversarial style of the time, prior to subsequent developments in law and practice, that there ought to be a radical departure from traditional cross-examination of vulnerable defendants and the introduction of specialist training for counsel in this respect. Whatever the style of questioning deployed, it is clear that Oliver was not able to give his best evidence, nor did the court take an active role in checking his understanding. As set out at paragraph 54 of my written submissions, in 2003, Oliver told Dr. Young that when he gave evidence at his trial, he had not understood the questions and did not think that the prosecution could understand him. He was confused, felt pressured, and tried to explain his difficulties in the witness box to no avail. The whole purpose of the current regime in respect of vulnerable defendants is to avoid that exact situation arising, and for the judiciary and counsel to be properly trained to intercede if a defendant seems in difficulty. Certainly, had an intermediary been appointed, they would have been sat next to or near Oliver in the witness box, able to intervene on the basis of the ground rules agreed or any other difficulties that they perceived. But in 1991, Oliver seems to have been left to fend for himself. He had no interventionist protection from the bar, bench, or an intermediary, as one would expect him to receive today. Turning to timetabling, as already established, Oliver would require frequent breaks to maintain concentration. It is apparent from the trial notes that he was in the witness box for 6 hours and 15 minutes over 2 days, with only the hour lunch break recorded on day one. The cross-examination of him on the 6th of December 1991 lasted for 1 hour and 15 minutes. While this is not of excessive duration per se, given the charge on which Oliver stood trial, it is the continuous nature of questioning for a prolonged period of more than 1 hour without any sort of break, which would highly likely be curtailed at trial today, given Oliver's vulnerabilities. We know from Dr. Young's report that even over a decade after his trial, Oliver had difficulty sustaining concentration for longer than 1 hour. This is sufficient to suggest that he would have lost concentration towards the end of the cross-examination. Applying modern standards, a short adjournment should have been scheduled for partway through, as well as unscheduled breaks permitted as necessary if he became confused or distressed. I have mentioned already general arrangements that could have been put in place to reduce intimidation and distress throughout proceedings. The fact that Oliver could not make himself heard when he started giving evidence is indicative of intimidation in the witness box. However, what is particularly concerning from the perspective of modern standards is not that these measures were seemingly not even considered by the court, but that judicial intervention while Oliver was giving evidence would actually have caused him considerable and unnecessary distress in front of the jury. During re-examination, Oliver was shown a newspaper extract. He said he could, and I quote, sort of read it. The judge then asked him to read it aloud, but he could not. We know that at the time of his trial, Oliver had a profoundly impaired reading capacity, and his literacy skills were the equivalent of those of a 7-year-old. Far from having the benefit of assistance in accessing written evidence, in line with current law and practice, Oliver was required by the judge to read aloud in front of the jury. This would have been a difficult, highly embarrassing, and traumatic experience for him. It is inconceivable that he would be put in this position without intervention were he to stand trial today. The Equal Treatment Bench Book quotes Judge Brian Doyle as saying, "Empathy is a quality all judges need. It is not partisanship, but understanding how someone is reacting to a process which is alien to most people." In 1991, Oliver faced a monumental task in an alien process, without any of the protections that are available today to ensure vulnerable defendants can effectively participate in their trial. He was not afforded the opportunity to give his best evidence. He did not come up to proof. We do not need to argue that nowadays a court would appoint an intermediary to assist Oliver, although that is a strong possibility. Were he to stand trial today, there would be, in one form or another, a tailor-made package of constantly considered measures designed to ensure his effective participation. We submit that the complete absence of all contemporary standards during criminal proceedings for the protection of vulnerable defendants renders Oliver's conviction unsafe. His Article 6 right to a fair trial was breached by modern standards to such an extent that the appeal could be allowed on this ground alone. unless I can assist the court any further.
No, thank you very much. Yes, Bernard.
Thank you. May I just say, make 2 points to follow up what Ms. Slowe has told you. First of all, the phrase monumental task, you may have recognized that from your reading of defense counsel's helpful observations. It was they who said that Oliver faced a monumental task in giving evidence. The second thing I wanted to say is about one aspect of the difference in adversarial style in those days, back in 1991, when I was a junior of about 20 years, and today. And one thing I well remember is that for a very long time, everybody at the bar and on the bench thought that it was essential, whichever side you were on, was that you put your case. You put your case to the witness. And so Mr. Bowl, who was a very gentlemanly and highly effective advocate, would have tried several times to put his case to Oliver on various aspects. And if he didn't get an answer, it was thought to be fair to the witness to repeat the question. Virtually the exact opposite of the system that Ms. Slowe has so graphically described to you. In perfect good faith, but actually, as we now know, misconceived. What I'm going to do now, at a rate of some knots, is to do 2 things. First of all, to mention to you a few paragraphs in our appeal argument. You have probably read them, but I haven't referred to them specifically, just in case you would wish to refresh your memories of them on matters that I haven't come to. At paragraphs 217 to 225, paragraphs 202 to 207, the perfunctory and biased investigation by police of Harvey admissions. 217 to 225, the agreement between prosecuting counsel and counsel for Eric not to adduce the Harvey admissions. 226 to 36, the voir dire. 237 to 49, Oliver's failure to come up to proof. 250 to 252, the judge's change of mind about the truthfulness and reliability of all of Oliver's admissions. And 253, the passage beginning at 253 in relation to the Court of Appeal judgment. So I'm going to go through a number of points briefly as to how we put our case, relating them to our grounds of appeal. But first of all, I want to deal with our underlying suggestion that Oliver is an innocent man. Now, I confess that the difficulty we have here is that we do not have what I would call a smoking gun. We don't have exculpatory DNA or fingerprint or anything that is physical proof that he wasn't there. But what we do have is a combination of circumstances so powerful as to give rise to the gravest concern that an innocent man was wrongly convicted. And just to remind you in a sentence, it is the combination of clearly false pressurized admissions, the repeated exonerations by Eric Samuel of Oliver, the hairs in the cap which could not have been his or Oliver's or Eric's, and powerful fresh evidence as to the risk of false confession, which you've heard this morning, reinforced by very detailed and careful reports. Might I just, on that score, address briefly a point which is clearly of concern to the court, judging by the questioning this morning. Very understandably, the professor was asked whether he could have come to a conclusion more favorable to Oliver. Let us assume that the answer to that is yes, that the science that was then available would have permitted him to go further than he did and to furnish to the solicitors a report which they could then have used and perhaps called him. I suggest that that is, with all respect, beside the point. Because the fact is that the report that we have and the letter that we have are the documents that the solicitors had. And maybe in an ideal world it might have been possible to find someone else who could have produced reports more favourable. It didn't happen. They can't be criticised for not having attempted it, and in my submission, it ought not to affect your Lordship's view on the admissibility of that evidence. They could not, by reasonable efforts, have acquired better evidence, and they were stuck with it. And again, the observations of counsel, you will remember, make it clear what a blow it was to them that they did not have expert evidence to call on Oliver's behalf as to why he might falsely have confessed. Now, against that background, may I take you, please, very briefly to our grounds of appeal, which you have to hand, and I will just run through them, reminding you of them, and making, from time to time, a few comments. May I say that the court will find the chapter and verse of our detailed reasoning for each one, beginning at paragraph 389 in our appeal argument. Round one goes to character and disposition and personality, and in the light of the expert evidence that you have heard, that is obviously an important matter. Identification evidence ground two exceptionally weak. Well, of course it was, because the judge said he would have stopped the case if that had been the only evidence. And the court will be very alive to the detailed exposition that the judge gave of those weaknesses in his summing up. I ask you also to bear in mind the striking point that Mr. Hoondle, who had the grandstand view in very good light of a man a few feet from him, did not pick out Oliver, and he made that photo fit which showed that he had a very good sight, look at the person, and in particular the hat. He got at least 7 out of 10 for his rendition of the hat. Round three, obviously no forensic evidence against him, and in fact forensic evidence highly favourable to him in the hairs that could not have been his. Four, again, we say, and this very much depends upon the impression that you had yesterday when we went through the material and excerpts were played to the court. Almost all the details that Oliver gave police of the robbery and shooting in his admissions were either contrary to the known facts or absurd. Insofar as they were correct, he could have obtained them without any involvement in the robbery from Crime Watch, the press, Eric Samuels, or even the police, with whom he'd spent long periods when no tape recording could be made. Then I come
Well, I wonder if that's a convenient point to remind you that you were going to address us at some stage about what the instructions were about what happened
yes,
at
well,
times when
in fact,
there was no recording.
That comes out in one of the grounds that I'm coming to.
Very good.
Yes, and I will give you the chapter and verse on that. And may I say that if you wanted to look at Oliver's instructions in detail, you have the whole lot because we have pursued the warts and all approach. You've got his proof and you've got all the attendance notes. But I will come to the short answer to that in just a moment. All of the admissions were made in the absence of a solicitor. Detailed analysis of the relevant documentation, including the custody records at both police stations, shows that the Crown could not prove that Oliver's waivers of his right to a solicitor were voluntary informed and unequivocal, hence they will all now be excluded. And I can yoke that together, of course, with the fact that either he had no appropriate adult, as at Plasto, or the one he had during the crucial interview, tape 11, Mrs. Jackson was, through no fault of her own, wholly inadequate. And my bull point here is this, that if you focus on Plasto, it is very obvious that his feet hardly touched the ground from the time that he came through the door of that police station to the time when they started to interview him. There was simply a perfunctory note on the custody record that he didn't want a solicitor, didn't want anyone informed, nothing about an appropriate adult, and taken straight for interview. So the notion that there might have been an unequivocal and properly informed waiver of his right to a solicitor, even for someone of ordinary intellect, is simply fanciful. And you will remember that he wasn't reminded of his right to a solicitor when that interview started. The reason that that is the bull point, say I, is that the lack of a solicitor and an appropriate adult tainted the rest of the interviews, tainted in the sense that the admissions that he then made led officers, in particular D.S. Ellison, to the conclusion that he must have been the gunman, led them to put pressure on him, which ultimately created a very grave risk that when push came to shove in the Jackson interview, he would confess falsely as he did. So if we're right about the Plasto interview, the process is tainted and everything is inadmissible, anything that is to his detriment. Then we say, and again you will find the chapter and verse, the appropriate part of the explanation in our appeal argument, there's powerful evidence in the prosecution papers that parce the trial judge's approval of his behavior after a voir dire, Ellison manipulated events to ensure that the Jackson interview took place in the absence of a solicitor. Then, paragraph 7, I've effectively dealt with this, ground 7, inappropriate, well, no effective appropriate adult. Then, paragraph 8, police negligence put Oliver in a false position. And this is Butters getting him to admit the dropping of the hat in the shop, and Ellison thinking that he'd admitted dropping it nearby, and a fatal misunderstanding, we say. And then we say much of the police questioning at Hackney was misleading, bullying, and unfair, and we give a number of examples. Repeated conversations with Oliver where no contemporaneous record could be made, exaggerations of the strength of the case, closed questioning suggesting, well, either it was an accident or deliberate, and repeated breaches of the codes of practice in regard to note-taking and the showing of notes. And we've done what I hope is a helpful schedule which will enable you to see in a few glances that what we suggest there is right, that the notes were never made in a timely way or shown in a timely way. Then at paragraph 10, we say even in 1991, and in the absence of expert evidence, a judge fully acquainted with the matters outlined in grounds 8 and 9 would very likely have excluded all the Hackney admissions under section 76 of PACE, or excluded all the admissions, including those of Plasto, under PACE section 78 on the grounds of unfairness. And alternatively, and we don't need to establish what might have been the position in 1991, it is good enough for us to establish that today that would be the position, as it undoubtedly would, we submit. And then powerful evidence in the defense files to suggest a number of matters. And I'll just take you to the last one, that over a period of months, Oliver was unable to recognize the significance of arrest and making admissions to police. And that touches upon the material in the defense files, which my Lord is interested in, and which will enable you to see the summary of his instructions, and then it will take you to the source documentation if you wish to look at it.
That's not the point I've repeatedly asked you about. The point I've repeatedly asked you about, and the court would welcome your assistance on this,
Sorry?
is your frequent assertions that various improprieties may have been committed by the police when
Yes.
the tape recorder was not running.
I'm sorry, but
I have simply asked
yes.
your assistance with what the defence case actually was about.
Oh, the defense sorry, I misunderstood. It is common ground, and you will see this from this common ground, that between us and those who acted at the trial, that they did not make any of the criticisms that we now make, and they make that plain in their observations to the court. And the furthest it went, we get this from the summing up, is that there was a hint of criticism, as the judge said, of D.S. Ellison for having arranged the Jackson interview in the absence of a solicitor. So I'm sorry, I had misunderstood your question.
Well, I'm sorry, because you've still misunderstood it.
Yes.
There are all kinds of reasons of tactics
Yes.
why counsel may or may not choose to pursue particular lines. The simple question, which I now ask for the final time, is what were the appellant's instructions about whether anything which the lawyers could identify as improper did in fact take place?
About the way that... Sorry, no. Yes, I'm sorry.
You are making accusations,
Yes.
Mr. Birnbaum, of police impropriety. You may be right, you may be wrong,
Yes.
but they're serious allegations to
Yes,
make.
my Lord.
And I want to know what was the evidential basis on which those allegations are made. It's quite a
The
simple point,
evidential
I think.
basis is not anything that Oliver said, because he simply made it plain. He gave a number of accounts of tried to give a number of accounts of why he had confessed, but he was not making any allegation against the police. The allegations against the police come from the views of the psychologists, who are very critical of their tactics. And in the case of certain matters I have put against Ellison, like manipulation to achieve an interview in the absence of a solicitor, or telling Oliver about the man Richard Clark, those are inferences from the material available to us, almost all of which comes from the prosecution. So they are our inferences from their material. Now, whether they are correct or not will be a matter for your lordships. And this is something that I would do if I were instructed today in a case I had the unused material, and I might say to the officer, well, on the basis of documents A, B, C, and D, you did the following improper or dishonest thing. That's the way that... I'm not suggesting that these were points that the appellant was making.
Right, thank you.
And I'm sorry I didn't understand. I'm grateful now that I've understood your drift, and I hope I've made it plain. Then we deal at round 12 with the recent reports and letters from Professor Johnson, which we say provide powerful support for our case. I have to say that I simply do not understand, and I await with interest to hear the argument as it will now be put, that all of this material is inadmissible. I am not going to repeat them, but we set out in our note, whose name I have temporarily forgotten. Yes, it was a note for the directions hearing. We set out at great length the many objections to that argument and the reasons why it is simply unarguable. But I just wish to say this, and I suspect it must have been a simple mistake, but an important one. What the Crown should have done, surely, was to obtain their own report. If that report had shown inadequacies in the report of the reports of the two witnesses we've heard from today, or errors of principle, the Crown could have acted accordingly and called the evidence. But they didn't do that, and they are now seeking to say to the court that you should ignore what appears to be opinion based on the most recent scientific research. Well, how can you do that? You are being invited, in effect, to behave as if there had been no further advances in the understanding of the risk of Oliver falsely confessing since 2004. It's inconceivable, I say, that you should do that. And it's a profoundly mistaken and, I suggest, unhelpful approach. What the evidence shows us is not that he falsely confessed, because they cannot say that. It shows us that the risk that he did so is a substantial risk, which was plainly not appreciated at the Court of Trial or by the Court of Appeal. And then unfair trial because of the failure of the Crown to call the Harvey admissions. Now, may I say this? This is a very, very unusual situation, and I don't know of a comparable case, although there may have been one. Because this is a case where, until the very last moment, the Crown, as Ministers of Justice, very fairly were going to call those admissions, and they didn't. Now, the way I put it is this, that was necessarily an unfair trial unless my learned friend can show you that those admissions were incapable of being believed by any jury at that time. Now, if he succeeds in doing that, then I ask rhetorically, what case would I be left with under Section 23 of the Criminal Appeal Act? Because if I am right, and this was credible evidence that should have been called at the trial, then the appeal must surely succeed on that basis. But if it wasn't credible material, if it was obviously a pack of lies, then I ask rhetorically, how could I invite my lord, the court, to admit it under Section 23? So our analysis is that it's unfair trial or nothing, if you follow my logic. And it plainly was an unfair trial because the jury were deprived of the opportunity of hearing what we say was probably the most important evidence in the case. And it could never happen today. That, I suppose, is where the legislation comes in. It could never happen today because under the 2003 legislation, a judge would undoubtedly admit it if he thought it was capable of belief by a jury. And then we say the summing up was inadequate and unfair in a number of respects. And those are summarized at paragraph 15. Paragraph 16 is the point that the learned friend has just dealt with, contemporary standards. And then 17 is perhaps more of a comment than a ground of appeal, but we do say that the that there was a basis upon which the Court of Appeal could have allowed the appeal, taking together the Harvey admissions and Sanders's evidence and relying on Beckford and Daly. And we have set that out in detail in our detailed argument. So, my Lords, subject to there being any other matter on which I can assist, those are my submissions.
Well, were you proposing to make any submissions about the relevant law?
The authorities that we rely upon are set out in the relevant parts of our analysis of the PACE protections, but more particularly under each ground. So, for example, vis-à-vis the right to a solicitor, the CADA line of authority, and so forth, and PACE and other matters. So you will find them all. And I just don't think that time permits me to go through them, having regard to my learned friend's right to all the time he needs. If there's any specific matter, I'll try to assist.
Well, the case raises some difficult issues.
Yes.
As to the jurisdiction of the court, decades after the event, to consider criticisms of what happened at the trial.
Consider
criticisms of what happened at the trial and developments since the trial. There are limits to what can be done. It is not the case that anyone who was convicted years ago could simply come to this court and say things would be different today. So we need assistance, please, with what the relevant principles are and what this court has said on previous occasions. Now, where do we find that in your many documents?
Yes. Are you speaking of the general principles that contemporary standards of fairness must be applied? Is that what you are thinking?
Well, that is one of the points,
yes,
Mr. Burnham.
And the others being...
Well,
I'm sorry, I'm seeking...
it's not for me to tell you how to present your case, Mr. Birnbaum, but you're raising matters. For example, one of the grounds of appeal you've just taken us to is a number of criticisms of the fairness or otherwise of the summing up.
Yes.
On the face of it, every point you make could have been taken at trial. There is ample authority that, as a general proposition, if a point could have been taken at trial,
yes,
it's too late to take it on appeal, unless one is saying, which you are not, that trial counsel fell badly short of professional standards.
I follow
so that's one aspect.
Yes.
And another aspect is whether relevant developments are statutory or merely differing views as to the developing views as to the common law.
Yes.
Another matter is a difference, perhaps, between a scientific development, the development, for example, of a new test, and a mere changing focus or emphasis. These are all difficult issues raised by this case, and I regret to say that so far we've had no assistance on them.
Well, my Lord, if I may say so, without disrespect, that analysis is helpful, but you have not raised those points with me. If you wish me to, I could produce a further document about them, but I imagine that you would not want to do that. May I do my best as I am on my feet to deal with them? You mentioned the summing up. The problem the judge had in relation to the summing up, and it was a real problem we have to accept, is that he knew that evidence had not been called which would have been probative of the innocence of the defendant. He therefore had to be, and he also had taken the view, it's a point specific to the peculiar facts of this case. We know from his report to the Home Secretary that he had taken the view that some of Oliver's admissions could not be correct, could not be right. And so we say that he had to be very careful and circumspect in his comments to the jury, and he overstepped the mark. Even by the standards of those days, he went too far. Now, in relation to changing standards of experts, I think it doesn't, I suggest to you that it doesn't matter very much how you categorize it. The fact is that the uncontradicted evidence that you've heard today establishes that there is a much wider range of factors that experts take into account nowadays than was available to them from the research in 1991 or even in 1994. And I stress, available from the research. One of the things that was extremely impressive about Johnson was he was saying, I was not prepared to go further than the science as it was at the time. Now, he knows better than you or I what that science was. And if that was his view, then that view has to be accepted, and it is not for me as counsel, or may I say for a judge, to say that he was wrong. Our bull point on that is that the defense solicitors, they did everything they could to help this man. They did not have a report of an expert that they could call. And so that cuts through a very interesting point that my Lord has made about how one might describe the scientific advances. In relation
Does it
to...
follow?
I'm sorry?
Does it follow from what you have just said?
Yes.
That in any case where Professor Gudjonsson or one of his colleagues gave evidence 30 years ago, there could be an appeal simply on the basis, well, they would view matters differently now.
Well, when you say any case, that is a very interesting question. No, not in any case.
Right.
Because there have been a number of cases where, say 10 or 15 years ago, experts gave evidence for Mr. Smith, the mentally challenged defendant, and the jury convicted and an appeal failed. And then experts come before the court and say, well, the science has changed. There's now a lot more known about Mr. Smith and the risk of his falsely confessing, so we'd like to tell you about it. And the lawyers say you should allow the appeal. It takes very strong evidence for such an appeal to succeed. But, forgive my using the term again, our bull point is not that there was weak or weakish evidence from psychologists at the trial. Our point is that there was none. And so my Lord does not need to trouble about the interesting and difficult question that he has raised. This is the special feature of this case. It was so long ago that there was no scientific evidence that could be called. And I think I said to your lordships, sorry, I've done it again, to the court, my lords and my lady. I think I said when I opened this appeal that in a strange way, the very age of the case comes to Oliver's assistance. So much is now so different in so many fields. The understanding of his infirmities, the development of the law on the right to a solicitor, and so many other aspects, that it's a totally different case. It would be a totally different trial today to the one that took place in 1991. And then there is another point that occurs to me, that I was reading the other night the case of Hussein. I don't have the reference in mind, but it's a case where I seem to remember that at paragraph 28, there was a quotation from the judgment in the case of Bentley, which said, in effect, that failures to observe principles which were in force at the time of the trial could be more important than failures to observe principles which had only come into force or being much later. I think that was the thrust of it, but I've probably put it rather inelegantly. It's Bentley. I think it was paragraph 28 for some reason, or 27 of the judgment in Hussein, but we could check it. Your Lordship remembers, of course, the case of Bentley, where there was retrospective criticism which was successful of an unfair summing up by one of the great judges of the 20th century. So are there any other points on that score of developing or changing standards upon which I can assist the court?
No, thank you.
Thank you.
Mr. Price, we're just going to rise for 5 minutes to take stock of where we're up to. At a directions hearing in this case on the 11th October 2023, the court, having considered written submissions and heard oral submissions, gave a number of directions. The court recorded, amongst other things, that the estimated length of the hearing was 2 days. At no time in the intervening months has it been suggested that that estimate was insufficient. If it was insufficient, the court should have been informed. We find ourselves in this unhappy position, and we spell it out so that Mr. Campbell and those taking a keen interest in these proceedings can understand. By the time Mr. Birnbaum completed his submissions, there was significantly less than 1.5 hours of the 2 days remaining for the respondent to make submissions in reply, and for Mr. Birnbaum to make the submissions in reply to the respondent, which he had helpfully indicated he would likely wish to make. That, in our firm view, would put the respondent under unfair pressure of time, and it would put the court under unfair pressure of time. In a case as serious as this, and raising the difficult issues it does, it is wholly inappropriate for the respondent and the court to feel under severe pressure of time. We add to that, though we regret to say it, that we are disappointed by the failure so far even to identify, still less to address, the significant and difficult issues of law which this case raises. One of the obvious reasons why the time estimate for appeals is so important and why it is imperative for advocates who feel it to be insufficient to notify the court office in good time is that it is, in practice, very difficult to assemble all relevant personnel to continue a hearing which has not concluded within its estimated time. So, to take a simple example, it is simply not possible for this constitution of the court to remain sitting together tomorrow and to continue this case tomorrow, even if everybody else were available. Nor is it simply a matter of saying, well, we can carry on next week, because each of the judges has their own commitments which have to be accommodated, and the same, of course, is true of counsel. So to adjourn the hearing of an appeal, part heard, as the lawyers say, in other words, not finished, but to be continued at a later date, is a step which the court does not take lightly. But we take it in this case because the failure to alert the court to what has proved to be the insufficiency of the time estimate and the failure thus far to address important issues of law leaves us, in our collective judgment, with no alternative. What we propose, with regret, to do is this. We will adjourn this appeal hearing, part heard. It will be resumed on a date to be fixed as soon as is practicable, though I warn everybody that that may not be very soon, for the reasons I've mentioned. We will, within the next 2 weeks, give written directions to the parties as to matters on which we will require oral submissions at the adjourned hearing to be preceded by suitable written skeleton arguments. We think it would be wrong to expect Mr. Price, on behalf of the respondent, to seek to make submissions about what has happened in the hearing so far without knowing what further matters must, in our view, be addressed. And so we will be able to make no further progress today. We regret that, but for the reasons just given, it is unavoidable. We will, within the next 2 weeks, send to the parties in writing directions as to the steps that require to be taken, and we will resume and continue the hearing as soon as is practicable, when it is possible to arrange a date at which each member of the Constitution and all counsel can again gather. I hope all that is clear. Mr. Birnbaum, is there anything you wish me to clarify?
Lord, no. Insofar as this is my fault, I apologise. I look forward to receiving your directions and to complying with them.
Thank you very much. Mr. Price? We're very sorry that Mr. Campbell and the bereaved family of the deceased and everyone else concerned with this case is unable to see it to a conclusion today. For the reasons we have given, that this is an important and difficult case, it must be properly addressed, and to that end we will have to adjourn now and continue at a later date. Thank you very much.
against Oliver Campbell. This is a reference by the Criminal Cases Review Commission under Section 9 of the Criminal Appeal Act 1995.
Yes, Mr. Price. Now, we concluded Mr. Birnbaum's submissions at the last hearing. We've received written submissions from both of you. Thank you very much indeed for those. And so we're ready for your submissions on behalf of the respondent. And can I just indicate that mid-morning, could you please find a convenient opportunity for us to have a break? For
By all means, my lord.
I'll leave it to you. But
By all means.
If it gets to 11:45, I'll be getting twitchy.
May it please my lords, my lady. I wish to begin my submissions by identifying what I have called 3 important constraining factors which will govern the determination of this appeal. Firstly, there is the law of evidence to do with the limits of expert opinion bearing upon the reliability or the truth of a confession. And, my lord, I will return to that topic a little later, and I believe I will be able to deal with it briefly. The second factor, constraining factor, is the important concession made on behalf of this appellant that no criticism can reasonably be made of the conduct of his defence at the trial or the first appeal. The respondent submits, insofar as this might be necessary, that the concession with respect is rightly made. My lord, we would suggest, and I know the court will have seen it, that one of the more remarkable documents in the case, if not the most remarkable, is the written response of Mr. Campbell's legal team, compiled more than 30 years after the event, to the questions that were raised with them. However, having made that concession, more than once it is submitted with respect, the conduct of this appeal has overlooked or has failed to acknowledge its important consequences. And, my lord, in the course of our submissions, we will identify some examples of what we say is an erroneous approach in this regard. The third such factor is this. Where on an application of the kind that was made by the defence at the trial to exclude evidence of interviews and of other statements made by the accused, a judge is asked to conduct a voir dire, it will usually be because there are important disputed facts which will need to be resolved by the judge for the purpose of the ruling that is required. That was the position in this case. The judge heard oral evidence from Mr. Mullinger, the appellant's then solicitor, from Ms. Jackson, his foster mother, from Ms. Jill Yeomans, who was a social worker and who acted as an appropriate adult in some of the interviews, including interview 10, which immediately preceded the interview in which the confession to being the gunman was made. The judge also heard from Detective Sergeant Butters to do with the conduct of interview 1, in which Mr. Campbell might be thought to have admitted to participation in the robbery, though he denied being the gunman. The judge heard from Police Constable Noel, who was one of the officers on the journey from the place of arrest to Plaistow Police Station. And of course, and perhaps most importantly, given that the main issue that arose for decision was the admissibility of the content of interview 11, from Detective Sergeant Ellison. And indeed, my lord, the main disputed facts surrounded events which had occurred at Hackney Police Station on the evening of the 1st of December 1990, events starting after the conclusion of interview 10, and leading up to the commencement of interview 11, when, as I have said, the admission to being the gunman was made. Now, in this appeal, a substantial attack is renewed on the conduct of Detective Sergeant Ellison during that period. He is accused of the most serious impropriety and an unscrupulous manipulation of events to secure an interview with an obviously vulnerable man in the absence of a solicitor. Upon examination, it is submitted by the respondent that this renewed attack upon the conduct of that officer is based upon no more than the same material which was deployed for the purpose at the trial during the conduct of the voir dire, which, for the reason we have already stated, it must be assumed was properly conducted on behalf of the appellant. This renewed attack is also based on what is described as new evidence. However, it is, all of it, taken from the solicitor's file, available to those representing Mr Campbell at the time, and indeed it largely consists of things that were said at the time by Mr Campbell himself to those who were then representing him about what he said had happened to him at the police station. But Mr Campbell did not give evidence on the voir dire. So, as must be accepted, a reasonable decision was made at the time not to use that material. My lord, the respondent submits that the judge's findings of fact about the critical events, about what happened in the police station between the end of interview 10 and the beginning of interview 11, as they are stated in the judge's ruling, are of the greatest of importance in the consideration of this appeal. And we will be submitting in the circumstances. I have just outlined the fact that a concession has been made that it was conducted properly, and that all of the material which is now sought to be deployed was either deployed at the time or was available to be deployed at the time. That being so, if it is correct, and we submit it is, that there is now no arguable basis upon which this court can be invited to go behind those primary findings about what happened by the judge who heard direct oral evidence from all of the principal actors in those events, save, as I've said, for Mr. Campbell, but in the circumstances that I've already described. The respondent submits that those findings by the judge cannot legitimately be impugned. Furthermore, we submit the new expert evidence which caused the Criminal Cases Review Commission to refer this matter back to the court does not, and obviously cannot bear upon those findings by the judge about what happened and about what D.S. Ellison did or did not do. Though may I say, by way of an aside, that some of the experts in their reports do take it upon themselves to comment on the conduct of the police. So, my Lord, by way of introduction, those are three constraining factors which provide the context for the consideration of the appeal. Beyond that, my Lord, I've identified some headings to do with events during the case which I wish to consider with the court in my further submissions. Can I first of all state what they are, and then I will come to my submissions on each. The first is to do with events on the 30th of November of 1990, starting with the arrest and leading up to the arrival of the appellant at Hackney police station later that day, and ending with the examination of him there on the afternoon of the 30th, which led to him being identified by the police for the first time as a vulnerable person entitled to the services of an appropriate adult. Secondly, I will be making submissions on the events which took place on the evening of the 1st of December, as I have said, between the end of interview 10 and the start of interview 11. Events which principally involved the appellant, his foster mother, Miss Jackson, and Detective Sergeant Ellison. My Lord, at the directions hearing in October of last year, the court identified 5 grounds of appeal which it designated as not requiring leave, I apprehend because the court considered that they were embraced by the terms upon which the CCRC had sent the matter back to this court. Those 2 topics that I have identified will be dealing with the matters which are the subject of 4 of those 5 grounds, namely those in 5, 7, 10, and 12, which are all of them, in one way or another, concerned with the admissibility of interview 1, interview 11, and the various other statements that were made by the appellant at the material time. The third topic that I propose to deal with, and again, may I say I'll be able to deal with it very briefly, is the question of modern standards and the submissions that are made about the absence at any of these interviews, an absence at the trial of an intermediary, and that, my Lord, relates to the 5th of the 5 grounds that the court designated did not require leave, ground 16. And the last topic upon which I propose to address the court, subject to anything else that the court, of course, wishes to raise with me, are the various statements of Mr. Samuels. And I will be doing that, my Lord, because, of course, they were identified, the evidence of those statements were identified by the Criminal Cases Review Commission as providing a supporting ground for the main ground upon which the matter was sent back to this court. My Lord, can I therefore please, first of all, direct the court's attention to the transcript of the judge's ruling following the voir dire, which is at Y brackets 1, 112 of the digital case system. First of all, matters proceeded before the trial judge upon the basis of an important concession made by the prosecution, by which they invited the judge to deem all of the statements as falling within the definition of an interview for the purposes of the application of the code. And that is dealt with. My Lord, I will give the court the page and paragraph references as I go through. That is dealt with at page 1D. Now, I don't seek in any way to go behind the concession, and of course, consistent with the approach I'm asking the court to take it, I proceed upon the basis that it was wholly, correctly and reasonably made. Nevertheless, my Lord, it does introduce an element of artificiality into the consideration of the matter, because on any view it would have been impossible to have provided the appellant with the services of an appropriate adult until after he'd first arrived at the police station. But all of that being said, the prosecution were clearly of the view that the judge should approach the matter upon the basis that for this defendant the available protections were to be taken as applying throughout. And that is the way in which the judge at their intervention dealt with the matter. It is next important to identify what objections were taken, given it is accepted that these proceedings were being competently and reasonably conducted. And, my Lord, that is dealt with at paragraph 8D. And the bases of the matters to which objection was taken, they are dealt with by the judge at page 8H and 16C to D, and I propose to summarise them.
So when you say page 8, is that Y1 120?
Sorry, my Lord, I should have... I'm using the page number of the document. So I'm using the page number at the foot of the document itself.
Yes.
My apologies.
8 of 87.
I'm
No.
page 8H, my lady, and 16C to D set out the basis of the objections that were to be advanced. And I'm proposing, if I may, to summarise them. I'm going to divide them into two parts, my Lord. First of all, objections which were taken to things said in one form or another up to the arrival at Hackney police station, and then separately those which thereafter happened. There were four matters of objection falling into the first category and 2 in the second. So dealing with the first 4, there was the conversation at the place of arrest. I don't know nothing about any shooting. I didn't shoot the man. The objection was based upon the absence of an appropriate adult, which was said to give rise to a consideration of unreliability under section 76(2)(b) of the Police and Criminal Evidence Act. The submission was that the absence of an appropriate adult was itself something said or done which satisfied the requirements of the section and required the judge to exclude that evidence. The second objection was what one might call a record-making objection, the failure to make sufficiently expeditiously a note of what was alleged to have been said. The second matter was the conversation in the police car on the way to Plaistow police station. The two grounds of objection were exactly the same. You mean the Asian man that got shot? I remember all about it from Crime Watch UK. Asked, What other murder do you remember? Only that one. Why just that one? I just do. And then the observation, someone grasped me. Thirdly, there is the first interview at Plaistow Police Station starting at 8:10 on that Friday, the 30th of November. It was conducted by Detective Sergeant Butters and PC Dobinson. In short, Mr Campbell admitted, or could be taken to have admitted, to participating in the robbery but denying being the gunman. There was a sole ground for objection there, absence of an appropriate adult, section 76(2)(b) of the Act of 1984. And then finally, there was the conversation in the police car on the journey from Plaistow Police Station to Hackney Police Station, during which Mr Campbell pointed out to the police the address which enabled them for the first time to identify, and correctly to identify, Mr Samuels as the other suspect in the case. My Lord, I'm not going to go through the conversations that took place there. That was the most important fact which occurred during that journey. But again, the ground for objection was the absence of an appropriate adult, section 76(2)(b) of the Act of 84. So, my Lord, as I say, the submission that was being made to the judge was that the very fact of the absence of an appropriate adult was itself the thing that was said or done meeting the requirements of the section. Can I then come to the findings of the judge? First of all, my Lord, dealing with what I have called the recording breaches, which he found there were such breaches, but the judge also found that they were immaterial. This is dealt with, again, using the page numbers of the document itself, at 29E to G. The judge referred to the compiling of a joint note by the officers at Plaistow Police Station. He took the view, therefore, that the breaches of the code had no impact on the accuracy of the recording of what was said. My Lord may recall that this issue arose at the earlier hearing of this appeal, when a question was asked of the court as to the extent to which there was an issue as to the accuracy of any of these informal statements by the appellant. May I say they are not all explicitly dealt with in the transcript of the summing up. But I would add that if there had been a specific issue in relation to them, one would have expected to see it dealt with. But there are two examples of two of the statements made in informal circumstances, if I can use that expression, where it is quite clear from the summing up that there was no issue as to the making of those statements. And the first is dealt with at Y(1), page 52E of the summing up. Which deals with the conversation about the girls to whom Mr. Campbell had told the police he had spoken about the murder. And the question that was posed by the judge to the jury for their consideration was not, were these statements made? It was what he was saying, Was what he was saying these things unreliably because he was under pressure from the police? My Lord, the judge further found, bearing in mind that the medical examination of Mr Campbell did not take place until the early afternoon when he arrived at Hackney, that the breaches of the code that arose from the absence of an appropriate adult in those circumstances were inadvertent. And that is dealt with at page 15A to C of the ruling on the voir dire. So,
just give me a moment, please.
Yes, of course, my Lord.
15A to C.
15A to C, my Lord, yes. So, my Lord, I propose to make submissions arising from this on ground 5, the absence of a solicitor, and ground 7, the absence of an appropriate adult. Two issues were being raised, going to the reliability of the record of the statements and the reliability of the content of the statements themselves. On the first issue, the judge's ultimate decision is further to be found at page 29 G to H of the ruling. And as I've said, my Lord, the judge's decision in that regard, we submit, was wholly vindicated by the course which thereafter the trial took. Now, my Lord, self-evidently, new expert evidence which is before the court, even if it is admissible, can have no bearing upon the judge's findings on that issue. But I turn perhaps to the more important and more substantial issue, the reliability of the statements themselves. First of all, my Lord, at the risk of repeating myself, the judge found that this was an inadvertent breach. In other words, he was not dealing with a case where police officers had deliberately tried to manipulate the circumstances so as to deprive someone as to the services of an appropriate adult when they knew they were entitled to it. Of course, and may I be the first to say it, that does not alter the fact that there was a breach and that the appellant was deprived of the services of an appropriate adult, he being someone who was highly vulnerable. He was deprived of the services of an appropriate adult and interviewed without one in interview 1. The judge's finding on whether the absence of the appropriate adult would have rendered unreliable any confession which might be made by him in consequence of that is dealt with at 29G to 30E. But, my Lord, the respondent would submit that because of a concession that was made on the part of those representing the appellant and presenting this argument, the really important issue that fell to be decided when considering the impact of an appropriate adult in these circumstances fell by the wayside. Can I begin what I have to say about that by, and I know the court will be very familiar with this, but my Lord, sometimes it does help to go back to the original material of what is said in the guidance about the role of an appropriate adult, which the court will find at section O brackets 4(1). And it's a very short passage, and I propose, if I may, to quote it. Your role is to assist, this is from Home Office guidance that was published in 2011, my Lord. Your role is to assist the detainee to ensure that they understand what is happening at the police station during the interviews and in investigative stages. In particular, you should support, advise and assist the detainee, ensure that the police act fairly and respect the rights of the detainee, help communication between the detainee, the police and others. You are not there to provide the detainee with legal advice. My Lord, considering that guidance, the Respondent submits that the critical issue that fell to be considered under Section 76 or alternatively Section 78 of the Act of 1984, when assessing the impact of the absence of an appropriate adult once Mr Campbell had arrived at Plaistow Police Station, and before he told the police that he did not want a solicitor and was then interviewed without one, is whether his consent to that was vitiated by the absence of an appropriate adult. If it was, may I be the first to acknowledge the consequences so far as the admissibility of interview one might appear to be obvious. But there is a short answer to that point, which is that no argument to that effect was advanced to the judge. No point was ever taken on the absence of a solicitor. The judge was not asked to exclude the evidence of interview one on that basis. And, my Lord, that is dealt with at page 16G to 17A of the judge's ruling.
Just rewinding one.
My Lord, yes.
The critical issue was whether his consent to the absence of
The solicitor.
was vitiated by...
Yes, my Lord. Upon arrival at Plaistow Police Station, the custody record was endorsed with the signature of the defendant to the effect that he did not wish a solicitor to be present.
Yes.
And I would submit that when it comes to considering, or when it came to considering what might the impact have been of the fact that he did not at that time have an appropriate adult when he was entitled to one, is whether the absence of such assistance vitiated the consent that he provided to be interviewed without a solicitor.
So could you just give me the page reference again,
My
Mr.
Lord,
Price?
yes. It is...
16.
My Lord, given its importance, I was actually going to, in this instance, go to it directly. It's 16G, 17A.
Yes. About the custody record.
Because it arose as a result of an interjection. The judge is saying the first interview was conducted, as I have already indicated, without an appropriate adult and also without there being a solicitor present. And then leading counsel for the prosecution, Mr Bowl, my Lord, may I interrupt to say I think your Lordship may be looking at the Hackney, obviously referring to the Hackney custody record, and the judge says, I'm looking at the wrong custody record. No point is taken on the absence of a solicitor. My recollection is that he had signed the custody record indicating he did not want a solicitor. My Lord, the Respondent would submit that that is sufficient to dispose of the argument with regards to interview one, because no criticism is nor can be levelled against the trial representation. None of the arguments which have been advanced in the grounds of appeal on behalf of Mr Campbell about whether his decision to proceed without a solicitor was, quote, voluntary, informed and unequivocal. Court will recognise that phrase as coming from its decision in the case of Saunders, 2012, 2 Criminal Appeal Reports, page 26. But the respondent submits that those submissions on behalf of the appellant now cannot be sustained unless there is some new evidence bearing upon the issue which is admitted by the court, and which operates to undermine the validity of the concession of the trial advocates that no point was to be taken on the absence of a solicitor. It wasn't to be submitted that it had been vitiated by the absence of an appropriate adult, and thus the decision of the trial judge acting in reliance upon that concession. Going back to the constraining factors, my lord, the respondent submits that the submissions which are made about what was asserted is the absence of evidence that the decision was voluntary, informed and unequivocal. This is an example of an argument which is advanced now on behalf of the appellant, but which cannot coexist with the concession properly made about the conduct of his defence at the trial and the 1994 appeal. So far as the latter is concerned, neither was this argument advanced at the appeal in 1994 on the back of new expert evidence which this court did agree de bene esse to hear during the conduct of those proceedings. My lord, dealing with the new expert evidence which it is sought to place before this court, none of it, the respondent submits, engages with, nor can it engage with this point about whether his decision not to have a solicitor was voluntary, informed and unequivocal. It can, of course, help to establish that Mr Campbell was someone who was entitled to and required the assistance of an appropriate adult, but so did the evidence at the trial. That was known to the advocates at the trial and by the judge. And the concession about the absence of a solicitor and the decision of the judge based upon the concession was made with that knowledge. The respondent's submission, therefore, on this matter affecting interview 1 is that nothing has changed. My lord, we submit there is nothing before this court to justify the exclusion of the evidence of interview 1, in which the appellant admitted he was one of the 2 robbers but denied he was the gunman. It is therefore further submitted that there is nothing to call into question the safety of his conviction on count 1 of the indictment, charge of conspiracy to rob, nor the admission by him during that interview that he was the robber wearing the British Knights baseball cap. And it has, of course, never been suggested that Mr Samuels was wearing such a cap. Now, my lord, I've said that the fact that the point was not raised at the trial is sufficient to dispose of the point. But if it's necessary for me to do so, and I submit it isn't, but there are further submissions that can be made, the respondent would say, which can demonstrate that the decision that was made was wholly reasonable. We now have material which can demonstrate why it was made. And indeed, there was material at the time available that would explain why it was made. Firstly, if such a suggestion had been advanced at the trial, that the absence of the appropriate adult vitiated the consent to proceeding without a solicitor on the basis that that consent was neither voluntary, informed, nor unequivocal, the prosecution would have been able to point out to the judge that on more than one occasion, Mr Campbell had been arrested and interviewed before the 30th of November and on each such occasion had used the services of either Mr. Mullinger or one of his colleagues. If, therefore, such an argument had been advanced in 1991, we submit it is inevitable that the prosecution would have referred the judge to such a history. The evidence of it was available at the time. Could I please give the court the relevant reference in the digital case system, section O, brackets 4, page 13. My Lord, there is furthermore new evidence to confirm that from a consideration of the solicitor's file in 1991, where at various points there are references to the fact that these solicitors had acted for Mr. Campbell on prior occasions. And there is one particular document which is genuinely new, which would not have been available nor known of by the prosecution at the time. And could I take the court, please, to page O, brackets 3, page 122, which is part of a letter that Mr. Mullinger sent to my learned friend, Mr. Birnbaum, in March of 2001.
Right, 03, page
122, my Lord.
Thank you.
First of all, at the top of that page, heading difficulties in establishing a rapport with Oliver at the police station. Oliver was an existing client of mine whom I had been representing in relation to a couple of minor matters. And then this, my Lord, this is the additional matter to which I wish to draw the court's attention. I recollect he popped into the office on at least one occasion to ask for my help with something unrelated to his cases. I think it was completing some benefit forms. My Lord, that is an example. I draw it to the court's attention because it is an example of the appellant himself seeking out his solicitor to ask for advice. And when one considers the evidence of Mr. Campbell's knowledge of solicitors that was available at the time and which is supplemented in that way from the letter of Mr. Mullinger, we would seek to characterize the position in this way. When Mr. Campbell made his choice on the morning of the 30th of November, it was therefore the case that he did not merely decline the services of a solicitor, he declined the services of his solicitor, of Mr. Mullinger. And by way of aside, we would invite the court to consider that alongside the fact that once later that day he had arrived at Hackney police station, Mr. Campbell said in clear terms to those then advising him, can I give the court the relevant reference from the solicitor's file, O brackets 3117, that he did not want Ms. Jackson or a social worker brought to the police station. And it is important also to record that his demand in that respect was accommodated by those representing him, even though it meant that the appropriate adult who initially attended at the police station was someone from Mr. Mullinger's office. In other words, he was being assisted in effect by two lawyers rather than by a lawyer and an appropriate adult. And her name was Maria Marshall, and I'll come to it a little later, but the judge himself found as a fact in his ruling that during the time the defendant was accompanied in the police station by Ms. Marshall, performing the role of an appropriate adult, she was not in fact someone who met the definition of that term as provided for under the code. But that situation was brought about, as I have said, because those representing Mr. Campbell wished to accommodate his desire that his foster mother should not be brought to the police station. My Lord, in summary on this part of the case, we submit as follows. What the appellant can and cannot do must have regard, we submit, to the empirical evidence of what happened on that day, to what he did and what he did not do. And on the days before that, and the empirical evidence shows that he could, and prior to the 30th of November has, decided when and from whom he wished to have legal advice or wished to have assistance at a police station. And the new material or the additional material that I am able and have pointed out to the court demonstrates, we submit, that the decision of those representing Mr. Campbell on the voir dire not to seek, by way of their application, to challenge his consent to an interview without a solicitor was wholly correct and was based on substantial grounds. A further argument which has been advanced before this court, principally in the documents, is that the evidence of interview 1 should be excluded under either Section 76 or Section 78 because it is asserted that Mr. Campbell was misled by an inaccurate statement by Detective Sergeant Butters as to where in relation to the shop the British Knight's cap had been found by the police. Again, the material to support such a submission, if it is one of substance, was available at the trial in 1991. And according to the records that we have available to us, the judge's ruling and the summing up, it does not appear to have been advanced either then or according to the record of the judgment of this court in the hearing of the 1994 appeal. There's no issue before this court but that the statement of Detective Sergeant Butters was indeed inaccurate. It did not accurately state exactly where the cap had been found and is to be regretted for that fact alone. But, my Lord, the simple point is that it has never ever been disputed but that the cap in question belonged to Mr. Campbell, and more importantly for these purposes, was a cap that had been worn by the gunman during the robbery. Insofar, therefore, as Detective Sergeant Butters' statement made it appear by what he said about where it was found that it was the gunman's cap, which after all is what mattered, it was wholly correct. My lords, my lady, that completes my submissions on events at and following the arrest and leading up to the appellant's arrival at Hackney Police Station, and what I have to say about interview 1, unless there are any further matters that the court would wish to raise.
Can I come back just with one question, just to make sure I understood the point you made a couple of minutes ago. You took us to one or more examples of the appellant, as it were, exercising his free will.
Yes.
To talk to a solicitor, for example,
yes.
about unrelated benefit matters. Is your argument that because there is evidence of him expressing his free will in that way,
yes,
it can be assumed that exercises of it, including the key one that we're concerned with, were, to take the three-word phrase, voluntary, informed and unequivocal?
Perhaps most importantly, my Lord, informed. And of course, what I'm doing is, I first of all I mainly rely upon the fact that a decision was made not to suggest otherwise on his behalf at the trial by those who represented him.
I have your point that the issue hasn't been raised before.
Yes, but I seek to support the correctness of their decision by drawing the court's attention to these matters. And where it leads ultimately in my submission is that what he decided to do on that day, as I've said, this wasn't someone who, for the first time, finds himself in a police station and is being asked whether he wishes to have a solicitor without ever having had that experience before.
Yeah.
This is someone who had a solicitor by name, whom he had used in such circumstances, not as serious, of course, but nevertheless within a police station, whom he had used before. And the decision which falls to be made, therefore, as to whether what he chose to do on this occasion was, and I myself need to check those three words, voluntary, informed and unequivocal, that is a material part of the background. And I suggest, may well be the reason why the point wasn't taken at the trial, and is a good reason why the point wasn't taken at the trial.
Yes. I suppose it might be said that whilst exercises of his will in that way may on the face of them have been voluntary and unequivocal, it's perhaps harder for us to know whether they were informed.
When I use the word informed, my Lord, I mean that he was not unfamiliar with the exercise of being asked, do you want a solicitor? I would submit that when that question was asked, it's reasonable to infer that his mind would immediately have turned to Mr. Mullinger. And the question that he would have asked himself is, do I want Mr. Mullinger to come here? And the answer that he gave was no.
Yes, I follow. Thank you.
Yes, thank you.
So, my Lord, I turn to the events on the evening of the 1st of December, 1990, between the end of interview 10 and the start of interview 11. These involved the appellant, Ms. Jackson, his foster mother, and Detective Sergeant Ellison. There were two matters which the judge was asked to exclude occurring during that period. First of all, a conversation between the appellant and Detective Sergeant Ellison that took place at 1955 when Detective Sergeant Ellison accompanied Mr. Campbell from the meeting he had just had, the private meeting he had just had with Ms. Jackson, back to his cell before shortly thereafter interview 11 began. The ground for the objection was not just 76(2)(b), but 76(2)(a). Those representing Mr. Campbell at the trial, in short, asserted that these events had been manipulated by Detective Sergeant Ellison so as improperly to bring about a set of circumstances whereby he could interview Mr Campbell without a solicitor. Engineering events so that he could obtain from Mr Campbell and from Ms Jackson consent to such a process when that wasn't real. My Lord, can I turn immediately to the judge's findings? And of course, these were findings of primary fact. The judge, having heard oral evidence from both Mr Ellison and Ms Jackson. Now, the first thing was that there was an additional objection to the conversation to do with a record-keeping point of the same kind that I had considered earlier. But, my Lord, if the court looks at the summing up dealing with it, and the relevant reference is it's at section Y, brackets 1, 67F to H, when it came to it before the jury, Mr Campbell's case was not that this conversation had not happened. He accepted that it had, and as the court will see from that reference, he told the jury he did not know why he had said those words, which included this sentence, "I shot the Asian man." So, again, we would submit on the record-keeping point the judge's decision that insofar as there had been a breach of the code, no mischief arose from it because the matter was not in dispute. But then going on perhaps to more important matters and the events themselves. The judge's findings were as follows. First of all, the judge found that Detective Sergeant Ellison was, quote, scrupulous, unquote, in seeking to comply with the code's requirements as they applied to someone such as Mr Campbell. My Lord, that is at 18H to 19A. There was a complaint and a submission made that at the conclusion of interview 10, there had been an agreement reached between Sergeant Ellison and Mr Mullinger that there would be no further interview that night. The judge found in terms that there was no such agreement. That is at page 23C. The judge found, having dealt with the matter to do with record keeping, the judge found, dealing generally with events on that evening, starting at 1955, that there were no breaches of the code. Paragraph 24, B to C. Ms Jackson had complained during her evidence that she had been allowed but a few minutes to speak in private with Mr Campbell. The judge found that she had in fact consulted privately with the appellant between 1937 and 1955, which was, as the judge said, significantly longer than the period which she had recalled. My Lord, page 24, E to G. Concerning the validity of her approval for the holding of an interview without a solicitor, the judge found as a fact that Mrs Jackson was aware that a solicitor had attended the previous interviews that day conducted at Hackney Police Station. That is at page 25D. The judge found that the consent of Mrs. Jackson to the interview proceeding without a solicitor was real and informed, and that she knew, despite her assertions in her evidence to him to the contrary, just what was at stake when she gave her approval to that decision. My Lord, page 30, G to H, and 31, E to H. The judge therefore found that Detective Sergeant Ellison both actually believed and further had good reason to believe that both Mr. Campbell and Ms. Jackson understood the significance of the interview taking place without a solicitor, and both had consented to that happening. And that is at 32A. My Lord, bearing in mind what is now said about Ms. Jackson, I propose to say a few words about her myself. And I'm going to begin, if I could take the court to page 3 of the judge's ruling, paragraphs G to H, because the judge reminded himself, and therefore it's helpful to us to look at it, of the then definition of an appropriate adult in the codes of practice, which included a relative, guardian, or other person responsible for his care or custody. My Lord, I draw attention to that because, of course, it has been submitted on behalf of Mr. Campbell that Mrs. Jackson showed herself during these events to be unsuitable to act as an appropriate adult. This submission was based, 1, on the fact that she reacted with distress to Mr. Campbell's confession. The respondent submits that that is not a fair basis on which to criticise any appropriate adult, and with respect is to misunderstand the nature of their role. An appropriate adult is not an independent legal advisor, and they are not there to dispense legal advice. They may often have a close personal attachment to the suspect in custody, and as I have just pointed out by reference to the judge's ruling, qualify as an appropriate adult for that very reason. My lords, my lady, it may often be the case, we submit, that an appropriate adult will be outwardly affected by their experience at a police station. The second criticism which is made of her is quite simply that she consented to an interview proceeding without a solicitor. We would respond that that assertion simply ignores the detailed findings of the judge on the issue. My Lord, standing back, the approach the court is being invited on behalf of the appellant to adopt on this issue, we would respectfully submit, has a circular quality to it. Ignoring as it does the judge's findings, it amounts to little more than assertion along these lines. Oliver is innocent, the confession is unreliable, therefore Mrs. Jackson failed in her task. My Lord, quite apart from the fact that she'd been Mr Campbell's foster mother since 1986, she was a lecturer in childcare and furthermore had been a magistrate since 1988. During the course of Mr Campbell's detention following his arrest, 3 people acted as an appropriate adult on his behalf. Firstly, as I've mentioned, Ms Maria Marshall. I said I'd come back to it, my Lord. Ms Marshall was specifically found by the judge not to qualify as such. And that is at page 19C to D of the judge's ruling. The second person was a Ms Jill Yeomans, who was a social worker, and the third was, of course, Mrs Jackson. My Lord, the respondent submits that considering the definition of the term that we have just looked at, she was far and away the most suitable of any of those who acted in that role on that day. Of course, to begin with, as I stated earlier, Mr Campbell had been explicit in telling his solicitor that he didn't want her to come to the police station. Could I please return to the judge's findings? My Lord, I've omitted to make a note of the page reference, but I will locate it earlier. I have the judge's words in quotation marks at this point. He said this: "At that stage, the defendant said something which may be of critical importance in the case. Unprompted, I want to tell the truth." And then the judge continues, and this is 25E to G. "On the way back to the cell, the defendant said, 'Something inside me is wanting to tell the truth. It's like a door opening inside me. I don't want to lie. I shot the Asian man.'" My Lord, the submission of the respondent is that those observations by the judge following the specific series of findings he had made about the events at the police station between the end of interview 10 and interview 11 amount to a clear finding that in the face of the representation that the interview was either oppressive or had been conducted in circumstances likely to render anything that might be said by Mr Campbell as unreliable, the judge had found that there was nothing which had occurred during those events which was improper, which had operated to deprive the defendant of his rights, that all of the decisions were made by people fully informed, and that there were no breaches of the code. And finally, in ruling, as we submit he did, that the prosecution had proved that the confession was not obtained in the way complained of, that it had come about because after meeting with his stepmother for the period that the judge found, the appellant decided he wanted to tell the truth. My lords, my lady, we submit there is nothing in the new evidence which can invalidate any of those findings. That which is relied upon either does not and cannot engage with it, or with any of them, and there I'm referring to the expert evidence, or it is not new. It was available at the time of the voir dire. and I'm referring to the contents of the file which are now relied upon, but which, as I've said, are almost all of them things which emanate from Mr Campbell, the appellant himself, and that a wholly reasonable decision was made by those then representing him not to make use of it, not to call him to give evidence to the judge on the voir dire. And, my Lord, to complete my submissions on this topic, since the decision of the judge on these matters and the determination of the first appeal in 1994, and now for the first time in responding to this appeal, the respondent, of course, also has access to the solicitor's file from 1990 to 1991. And if it is necessary to do so for the disposal of this appeal, as the court knows, we have an application to adduce fresh evidence which arise from that file of 2 further statements by the appellant. The first one was at 13:20 the next day. The record of it on the digital case system is at section O, brackets 3, page 26. It refers to something said by Mr Campbell in a private consultation with his solicitor while still at the police station. He had told the police everything as something inside him made him tell. He couldn't remember where the man he was with lived or remember what he took. He thinks he slipped and pulled the trigger of the gun and thought the gun was empty. Now, my lords, my lady, insofar as the appellant may be entitled to rely on the observation or opinion which is expressed in the note by its author, querying whether what was being said was a confession or a story, and it must be questionable whether that observation would be admissible, but in any event, the respondent would draw attention, first of all, to the similarity of the language used the previous evening with Detective Sergeant Ellison when the latter was accompanying Mr Campbell back to the cell after the meeting with Mrs Jackson, because the words attributed to Mr Campbell, which during the trial he did not dispute, are "something inside me is wanting to tell the truth. It is like a door opening inside me." Words to Mr Ellison. He told the police everything as something inside him made him tell. Words to his solicitor. And if that is not enough, a doctor at Feltham on the 6th of December recorded Mr Campbell as saying, quote, "The shooting was an accident. His co-D had a gun as well and no one was supposed to get hurt." The reference for that, my lord, is section O, brackets 3162. And could I, my Lord, make one final reference before, and I note the time, inquiring whether the court would wish to take its break. The other reference, my Lord, is this. Mr Campbell himself was able to recall and tell his solicitor about that conversation with the doctor on the 6th of December. He did so 8 months later, on the 6th of August 1991, and the reference for that is section O, brackets 3, page 102. 102, my lord. My Lord, looking at what's left, can I say there's a good chance I may finish before lunch, but if I don't, it will be very shortly thereafter.
Thank you. Can you just give me a moment to find the reference? 6th of August 1991.
Yes, my
Oliver
Lord.
explained the prison doctor had been asking him questions about
That's
the
it, my Lord.
shooting.
Yeah.
Okay. Thank you, Mr. Price. Is that a convenient moment to break?
If you please, my Lord, it is.
We'll just take 5 minutes or perhaps a little bit longer. Thank you.
Court rise.
Court rise.
Thank you very much. Yes, Mr. Price.
My Lords, my Lady, may I please emphasise that those two subsequent statements by Mr Campbell to his solicitor the next day and to the doctor at Feltham 4 days later, the respondent does not ask the court to admit those as new evidence for the purpose of proving the truth of the confessions. Because, of course, under Section 76, one is not concerned with the question of whether or not they are true. We ask the court to admit them upon the basis that the respondent relies upon them as further evidence to support the correctness of the finding of the judge on the facts, namely that it was proved that the confession was, in interview 11, and to Mr Ellison on the way back to the cell, was not brought about by oppression, nor in consequence of anything said or done which might render a confession unreliable. Rather, as we submit the judge found, it came about because Mr Campbell wanted to say it, and did so of his own free will to Detective Sergeant Ellison on the 1st of December, in his interview that night, to his solicitor in private 18 hours later on the next day, and to a doctor in confidence 4 days after that. And so, my lords, my lady, in that context, I turn, and I said I would deal with it briefly, and I, subject to any question the court asks of it, I propose to be brief. What of the expert evidence which is now relied upon and was the basis of the reference by the Criminal Cases Review Commission? Can I begin my short submissions on this topic by asking the question, what should it have tried to achieve? Well, my lords, as a part of the circumstances against which the judge had to make his findings for the purposes of considering Section 76 of the Act of 1994, he set out very fully the agreed evidence about the vulnerability of the appellant which had been placed before him. As I've said, there was quite a bit of evidence about which there were quite a number of matters about which there was a dispute during the voir dire, but there was no dispute about the evidence that was placed before the judge to do with Mr Campbell, the appellant himself. And the judge deals with this at considerable length at pages 9H to 12E of the ruling. And there was before him agreed expert evidence from Dr. Jackson, a neuropsychologist, Dr. Legg, a consultant neurologist, and furthermore, and this part of her account, of course, was not in issue, oral evidence from Mrs. Jackson about what she could say about the appellant having been his foster mother for the previous 5 years. The respondent submits that if it was to perform its proper role, further expert evidence should have sought to inform the court about any subsequent changes or improvements in the relevant medical science, and of any reassessment of the degree of vulnerability of Mr Campbell, so that thereafter submissions might be made on his behalf by his legal team, which could seek to demonstrate to the court how those changes in the evidence about him should cause the court to re-evaluate the important findings of the judge in connection with the issues that had been raised on the voir dire under sections 76 and 78. Now, my Lord, if that analysis be right, if that is a description of what the proper role of the expert evidence should have been, and of course the court will recognise I'm referring to the principles which are set out by the decision of the Judicial Committee of the Privy Council in the case of Pora, given the nature of the judge's findings, the most important of which, of course, were to do with what happened at the police station on that night, it is not easy to see how that objective might have been achieved, and which perhaps explains, the respondent would submit, why an attempt is made in this appeal to relitigate those findings of fact, but which in doing so can deploy nothing which is new or which was not available at the time. My Lord, what instead the new evidence does is, in effect, it confronts the court with rival rulings. Here's why I consider the confessions are unreliable. And the respondent does not shrink from saying, by reference to the case of Pora, that that is wrong and should not have happened. I might put it, my Lord, in this way. The expert evidence and the submissions which are made upon it exhibit no deference whatever to the findings that the judge made about the events which took place on the night of the 1st of December. And therefore, we submit, the new evidence should not be admitted by the court, because it is neither necessary nor expedient in the interests of justice to do so. One, because it does not afford any ground for allowing the appeal. It does not and cannot engage with the important findings of fact by the trial judge. And two, it would not have been admissible at the trial, because it would not have been open to the experts to express their opinion on the reliability of the confessions. My Lord, the Criminal Cases Review Commission, in its analysis of Pora, we submit, seem to want to treat it as a one-off critique of the expert in that case, which, of course, as I know the court will have observed, was Professor Gudjonsson. I wish to emphasise in making this submission that, of course, and I know the court will understand this, I'm advancing no personal criticism of that witness at all. I am not relying on the case of Pora for the fact that he was involved in it, and he is a witness in this case. I am relying on the case, or we are relying on the case of Pora for what it says on a point of principle, which, and we submit, accurately represents the state of law on expert evidence in relation to this discrete issue. For the simple reason we submit that it is not appropriate for experts to do that. One, because it is of no assistance to a judge in deciding issues under Section 76 or 78. And two, in relation to a very sensitive issue of fact, upon which a jury may be called upon to consider any number of different facts and circumstances, it is trespassing on their role in such an issue for an expert to express such an opinion. My lord, my lady, that completes my submissions on events at Hackney and into 11, and I was going to turn briefly to ground 16.
Yes, thank you.
The respondent is more than willing to concede that if someone such as Mr Campbell was to be facing trial on a serious offence today, and a court was to be presented with the evidence about him which was available to the trial in 1991 and is summarised by the judge in the part of his ruling that I have identified, we are quite prepared to concede and would invite the court to proceed upon the basis that it is highly likely that he would have been afforded the services of an intermediary, at least to assist him in giving his evidence. But, my lords, my lady, it does not follow from that that the fact he did not have one renders his trial unfair. My lord, ground 16, we submit, has to be considered within the context of what the court decides in relation to the wholly discrete grounds to do with the reliability of the confessions. I've completed my submissions on those matters, but may I put it this way? If the court were to reject the respondent's submissions with regards to the issue of reliability, then, of course, it's always a matter for the court to decide whether its decision on such matters renders the conviction unsafe. But being entirely candid with the court, if the court were of the view that the evidence of these confessions should now be excluded under Section 78, I would not seek to sustain the safety of either of the convictions of the appellant. So I make these observations within that context. If our primary submissions are rejected, the appellant might be thought to have no need of ground 16. But, my lord, if the court upholds the respondent's submissions, and one is faced with a situation of considering what would have been the impact upon the appellant of a trial and the absence of an intermediary where he was faced with trying to explain the evidence of the confessions which the court considers is admissible, then, as the file of his solicitors demonstrates, and the court will have seen, there are replete references to this, even in the most favourable circumstances. He has never been able to provide an explanation for these statements if they are not true. And the respondent submits that that difficulty does not arise from the fact that he does not have or did not have an intermediary. It arises from the fact that there is no answer that anyone could provide to that question. My lord, in the written submissions that the respondent provided in answer to the court's further directions, I refer the court to the case of Cox, which was a decision of the then Lord Chief Justice, considering the implications of the absence of an intermediary of a defendant on a charge of rape, where there had been a specific finding that he ought to have one. And that case, of course, as ever, the court had to consider the specific facts of that case, but nevertheless, the case establishes the principle that the absence of an intermediary does not of itself amount to unfairness, or renders a trial where one might be thought to have been needed unfair. My Lord, I was going to turn to my final topic, which are the statements of Mr. Samuels, unless any questions arise from what I've said on ground 16.
Just give me 1 second. No, thank you very much.
Thank you, my Lord. So far as the statements of Mr. Samuels are concerned, my learned friend Mr. Birnbaum has prepared for the assistance of the court a most helpful schedule which sets them all out. It's at CACD 1 2028. My Lord, the Section 23 of the Act requires the court, in deciding whether to admit evidence, to take account inter alia of whether it would have been admissible at the trial, which therefore means that the law that the court is called upon to consider is the law in force at the time of the trial. And the reason for that, may I say, is obvious. How could one expect the trial to be conducted other than on the law which applies at the time that it is held? In this case, since the trial was held and since the first appeal, Mr. Samuels has died. So the facts have changed since the court considered the issue of admissibility in 1994. And it is really on the basis of that change that the Criminal Cases Review Commission has invited the court to consider the issue of the Samuels evidence by reference to the current law of admissibility under the Criminal Justice Act of 2003. My Lord, I've attempted to state what I submit the correct position in law is, and I don't resile from that. But in the circumstances of what is said on behalf of the appellant arising from the evidence of Mr. Samuels, and the assertion that it demonstrates that these convictions were a miscarriage of justice, the respondent does seek to engage with this issue by reference, perhaps, to something that this court said in the case of Wallace, which I have cited in the respondent's written submissions in answer to the court's directions. In our view, it is...
Which paragraph? So we can
do forgive me, my Lord. It's the case of Wallace, and this is at page 298. Wallace is 1978, 67 Criminal Appeal Reports, 291, and what I am about to quote, it's only a very short passage, is at page 298.
So where do we see this in your recent written submission?
Sorry, my Lord, may I just... Yes, if the court has those submissions, it's at paragraph 10. And if one scrolls down to page 12, there is the quote there, and the title of the case has a hyperlink to the full report.
Yeah.
But in our view, it is quite impossible for this court to overturn these verdicts of this jury simply upon the basis of this bundle of inadmissible documents. So to do would, in our view, be quite wrong. It is unnecessary in this judgment to go any further than is necessary for the decision of these particular appeals. And then there's these words which I have emboldened in my document. We are not saying that there may not be a case in which this court, in its pursuit of justice and its constant efforts to see that there shall be, so far as is humanly possible, no miscarriage of justice, may stretch points in favour of appellants and take into account evidence which perhaps, on a strict view of the laws of evidence, it ought not to take into account. And, my Lord, my Lady, the submissions that I propose to make are within the spirit of that observation of the court in Wallace. But before I come to that, I wish to say a word about the criticism that was made on behalf of the appellant of the conduct of the prosecution at the trial in relation to decisions that were made about evidence that was to be placed before the jury. First of all, and this appears at number 1 in my learned friend's schedule, there was the evidence of the first reaction of Mr. Samuels to being arrested for his alleged involvement in this robbery. Now, at the trial, Mr. Samuels, of course, was admitting being one of the 2 robbers. He had pleaded guilty in count 1 to a closed conspiracy to rob with this appellant. And it was his case that he had not committed murder because he did not know of the carrying of the gun. And the evidence of that first statement by him upon being first arrested was a mixed statement in which, of course, he admitted his involvement in the offence, but also put forward part exculpation of his role. And therefore, that was always going to be placed before the jury because his representatives wished the jury to have evidence of his admission combined with that exculpatory statement. In a few words, it summarised the very heart of his defence. There was then, of course, and this also appears in my learned friend's schedule, at item 6.
Sorry, can you just give me the page reference again? I think I've got the wrong page reference for the schedule.
The schedule, my lord. CACD 1 2028.
212.
Oh, my
that's why I can't
apologies,
find it.
sorry.
Right, thank you very much.
I've got the link, but I've mistyped the number. Sorry, my lord.
2128. Right, thank you very much. Yeah.
Now, at the trial, objection was taken to the evidence of this statement by Mr. Samuels because of suggested breaches of recording requirements under the Police and Criminal Evidence Act. And the prosecution decided to concede the argument. The matter wasn't raised before the judge, and therefore the evidence of this statement was not placed before the jury. And there has been, as I understood it, criticism of the conduct of the prosecution in that regard as not acting in accordance with their duties as ministers of justice, because the jury, having heard the evidence of the first statement by Mr. Samuels, which was material to and supportive of his case, that's why it was admitted, didn't hear this different and inconsistent statement, the first of which carried with it an an inference that Mr Campbell was the other robber, whereas the second one said it was someone else. The short answer to that point, my lord, and the jury were so directed with regards to the first statement by Mr Samuels, is that it was not admissible in the case of Mr Campbell. It would not have been open to the prosecution in anything they said to the jury to rely upon what Mr Samuels had said upon arrest in support of their case against Mr Campbell. If the prosecution had resisted the application on behalf of Mr Samuels to exclude the later statement, and it had gone before the jury, it would not have been open to those representing Mr Campbell to rely upon those parts of it which were supportive of his case. The simple fact of the matter is that in relation to both statements, what Mr Samuels had said about Mr Campbell was inadmissible because it was hearsay. And we submit that in making the decisions which the prosecution did about what they should agree to be excluded when the matter arose, was to be informed by the law as it applied. And it was no breach of their duty to agree to the exclusion of evidence or a statement favourable to Mr Campbell if in fact it was inadmissible for that purpose. And we respectfully invite the court to reject the criticisms which have been made of the conduct of trial counsel in that regard.
Can you just help me with this, Mr Price? Was any point taken about this by the defence at trial?
My memory is stretched, my lord. I believe, because we have some notes, and I know Mr Birnbaum will have this at his fingertips, but my memory is, because we have some notes of counsel, that at the very least it may have featured in discussions between counsel on the point.
No, between counsel, yes, but
Yes.
Did anybody make any application
Lord,
to the judge saying this is unfair?
Where I believe it may have arisen, at least in part, is in the argument on severance, which occurred right at the start.
Right. All right. Thank you.
But so it may have featured as part of that, to my recollection. My lord, the respondent's submissions on that would be, insofar as any criticism might be made of the judge's decision, if any is, that it was well within the judge's discretion, applying standard principles, to decide that the inadmissible features of evidence that might arise during the course of a joint trial could very adequately be dealt with by appropriate jury direction, which is what the judge did. The jury were directed in the clearest of terms that that statement by Mr Samuels, and my lord, I don't have it at my fingertips, but I can find it shortly if necessary, was not admissible in the case of Mr Campbell, exactly as the court might expect.
And wasn't that one of the grounds of appeal in the Court of Appeal?
My lady, I believe that there may have been an issue raised to do with the decision of the judge on severance. Indeed, yes. And this court found that it was well within the discretion of the judge to have made the decision that he did.
Thank you.
Of course, my lord, statement by Mr. Samuels that was not in evidence before the jury. They knew he had pleaded guilty in the sense that he had admitted participating in the robbery. But the prosecution never applied to the court that they should know that he had agreed to conspiring in a case which involved only 2 robbers with this appellant. And of course, one can readily understand why the prosecution didn't seek to rely upon that, because it would have, under Section 74, it would have reversed the burden of proof on the central matter in issue in the case of Mr. Campbell, and that would have been unfair. But what is overlooked, the respondent submits, by the Criminal Cases Review Commission and in the submissions which are made on this topic on behalf of the appellant, is that once an exercise is embarked upon in which the hypothetical scenario which is foreseen by the Criminal Cases Review Commission and by those now representing the appellant is that in a trial conducted today, the statements made by Mr. Samuels exonerating the appellant would be admitted under Section 116(2)(a) of the Criminal Justice Act. But surely, my Lord, to extend that hypothesis further, if a trial judge was faced with such an application, and in response the prosecution then said, well, if the jury is to hear of these statements from this deceased witness, what about the others? In our respectful submission, it would be near impossible for the judge to refuse that application, because to do otherwise would bring about a set of circumstances where, in effect, the jury would be being misled about what Mr. Samuels has said over the years about who it was he committed this robbery with. And, my Lord, it would be a remarkable thing if the jury should hear of the informal, out-of-court statements by Mr. Samuels on this topic, which have no obvious immediate consequences, whether for him or for Mr. Campbell, but should not hear of the evidence of his formal statements within court, where he admitted his guilt to an offence of conspiracy in terms identifying Mr. Campbell as being his co-conspirator, because those were the particulars on the indictment of the charge to which he pleaded guilty. So whereas it would undoubtedly have been unfair for the evidence of that conviction to reverse the burden of proof against Mr. Campbell at his 1991 trial, if hypothetically now an application were to be made to a trial judge to admit the other statements of Mr. Campbell, we submit that the trial judge would be entitled to say, well, if that is what is going to happen, the jury will necessarily have to hear everything that this man has said, including of his plea, and even though it reverses the burden of proof upon you on the central matter in issue. And what one might have added is that the judge might say, you are bringing this on your own head. My Lord, the respondent's submission is that if one looks at the hypothetical suggestion advanced in the round by the Criminal Cases Review Commission and on behalf of the appellant in the submissions as to Mr. Samuels, if one looks at it in the round and asks the question, is it really the case that an application would be made in a trial now to admit the evidence of the statements of this man before a jury, it is very difficult to see how anyone could think it would be in his interest to do so, because of the consequences which would assuredly follow, especially having regard to the operation of the effect of Section 74 of the Police and Criminal Evidence Act of 1984, whereupon the jury hearing of the evidence of the conviction of Mr. Samuels, the burden of proof would have been reversed as to the issue of the identity of the other robber. Secondly, if one is to look in the round at the statements of Mr Samuels, those that exonerate Mr Campbell and those that incriminate him, we submit that far and away the weightiest is the first. One, because of course that represents his first reaction to being confronted with the allegation that he had participated in this robbery when he was arrested for it. And two, as was pointed out by this court in its judgment in 1994, and the reference is Q-1, page 12, to the evidence of a witness, Anne Winter, who lived above the shop where the robbery took place and overheard the robbers running away. And what she overheard passing between them, the respondent submits, and this court observed in its ruling, chimes with what Mr Samuels said when first arrested. The witness was called Anne Winter, and the account in the judgment of the court in 1994, that account was supported by a witness, Anne Winter, who, seconds after the shooting, heard a man who can only have been Samuels shouting as they ran away, "What on earth have you done? I never dreamed you would resort to that kind of violence." And what is it Mr Samuels said on the 4th of December? "I'm no murderer. I couldn't believe it when he shot him. I didn't even know he had a gun. I never went in the shop. It was him who went inside. I was outside when he shot him." That is exactly what he was overheard shouting as he ran away. So, my Lord, although the respondent can properly oppose the admission of the evidence of the exculpatory statements of Mr Samuels upon the basis that they would not have been admissible at the trial in 1991, we would advance the alternative or additional ground that the evidence or the new evidence of these statements should be excluded because they are not capable of belief. The respondent's submission with regards to Mr Samuels is that at best, so far as the appellant is concerned, he has been hopelessly, forgive me, inconsistent, and that the introduction of his evidence would have the effect of reversing the burden of proof at any trial conducted now. But at worst, upon looking at what he said on the various occasions, for the reasons which I have just advanced, far and away the most compelling statements of his is the first that he made, because it is supported by other evidence in the case. And finally, my Lord, on this topic, and these are matters which are set out towards the foot of the respondent's notice, there is now new evidence bearing upon this issue which is available to the respondent. And these are matters that I have dealt with at paragraph 23 of the respondent's notice. Can I summarise them in this way? First of all, there is evidence from the file to show that at the time of the robbery of the shop, Mr Campbell was someone who was familiar with the use and the holding of firearms, because he'd been in the Territorial Army. Secondly, it has always been his case that what he was able to say about the robbery was because of what he had seen on Crime Watch that was broadcast in September of 1990. in the respondent's notice, we invite the court's attention to a chronology which we there set out of various statements occurring in particular, according to Mr Campbell, between him and Mr Samuels, which demonstrates that he was speaking with Mr Samuels about this matter long before that programme was ever broadcast. And that the material available from the file enables the respondent substantially to undermine the assertion on his behalf that knowledge which he had acquired was acquired from that television programme. My lords, my lady, in response to this appeal, those are our submissions, unless I am able to assist you further.
No, thank you very much indeed.
Lord, thank you.
Yes, Mr Campbell.
My Lord, may it please the court, may I begin by conducting an audibility test? Can you hear me?
Yes, thank you.
Yes, thank you very much. I will try to keep it up. I would like to begin by observing that I had come to this court today looking forward to answering rather a swingeing objection to the whole of the expert evidence, which was, as I'm sure we all understood it, that all of it contravened the ultimate issue rule. We had sought to answer that objection in a detailed note, most of which, I'm happy to say, is now unnecessary, because this is, if you like, the case of the incredible shrinking objection. The objection is now limited to that part of their evidence where the experts comment on the reliability of Oliver's confessions. I shall presently refer you to 4 cases which show that experts in this field have for a long time been allowed to express views on reliability. But my point at the moment is a more general one, and it's this. Let's suppose that Mr. Price is right, and all the reliability views that they've expressed are inadmissible. It barely matters, because so much else of value that they say is now by implication conceded to be admissible. And I highlight, in a general sort of way, 3 matters. First of all, the extent of his vulnerabilities, as they can now be understood in the light of the 2003 findings of, I've forgotten her name, Dr. Young, influenced by information now available from the police and probation files about Oliver's compliance. So the extent of vulnerabilities is the first area of admissible expert evidence that we have from Johnson and Beck. The second is the use by police of interview techniques which are known by research to create a real risk of false confession by the vulnerable. And the third is his need for help and support from a solicitor and from a qualified appropriate adult. And you know what I mean by a qualified appropriate adult, I'm sure. And you will remember the particularly striking point made by Dr. Beck in her evidence, that as she put it, the appropriate adult would need to work hard with the police to make sure that they and Oliver understood one another. A point often missed, I think, in this sort of debate is that the appropriate adult can be as much to the advantage of the police as to the advantage of the defendant. So, I say, please let us pause there and put those factors together with the concession that my learned friend very helpfully and fairly made. And his concession, as I understood it, was this, that on the material available at the trial, that is, at the trial in 1991, Oliver today might well have an intermediary, at least to assist him in his evidence. At least to assist him in his evidence. What follows from that? The evidence that the court had about Oliver's infirmities was helpfully rehearsed by my learned friend a few moments ago, and it was significant. But it was a great deal more than the nil evidence that the police had of his infirmities. They had no idea of them, and indeed Oliver did not help himself when he agreed with a leading question from Mr. Ellison that his problems did not affect his memory. And so, if he might well have been entitled to an intermediary by concession at the time of the trial to give evidence, surely that reinforces the contention that he should have had a solicitor and an appropriate adult at every interview, and reinforces the contention that he could not possibly have understood the importance of having a solicitor. I say that if only for this reason, that you may recollect that at the second interview, that is the first at Hackney, after he has admitted being the lookout, although he subsequently at Plastow starts to withdraw that, he's asked who he is. He says, "I'm Oliver Campbell, and I'm a witness." So much for the man who understood the need for a solicitor. So my point here is that if we put together the parts of the expert evidence which are now conceded to be admissible, with the concession that he might well have an intermediary today if he were tried today, we get a very powerful evidence, a very powerful submission that the appeal should succeed because he didn't have a solicitor and an appropriate adult at every interview and could not have an intermediary. If the appeal were to succeed on that basis, and on the learned friend's argument it ought to, then of course that would not affect the issue whether he's guilty or not, but the conviction would be unsafe on those three bases. And I say effectively that I am shooting at an open goal, if you will forgive that sporting analogy on that point. My learned friend makes an interesting submission about why I am not entitled to take points about what counsel did or did not do at the trial or on the appeal. And he says, in effect, if I've got him right, that having conceded that they were not incompetent and that their conduct cannot be impugned on that sort of basis, I cannot go behind that concession and seek to say, well, they could have done this, that, or the other. Well, first of all, it is very clear from their very fair and careful note that for whatever reason, they did not take most of the points of criticism and analysis which we are taking on this appeal. They didn't. And I don't say that they were incompetent in failing to do so. But it's important not to confuse two different points. And forgive me while I turn to a relevant part of a typewritten note. Point one is the criterion upon which the Court of Appeal may act where it is faced with criticism of counsel as having acted incompetently. And the case of Clinton, which you'll find referred to at Archbold 783, although I don't need to take you to it, shows the conviction's not unsafe if the decision of counsel was made in good faith after proper consideration of the computing arguments and, where appropriate, after due discussion with the defendant, even though the Court of Appeal may disagree with them. Conversely, and I'm sure this is a familiar principle, if a decision was taken either in defiance of or without proper instruction, or when all promptings of reason and good sense pointed the other way, this may render a conviction unsafe. Well, I'm not seeking to do that. But the fact that I'm not seeking to do that does not preclude me from saying to the court, please consider these points in the light of modern standards and consider whether, in fact, the interviewing was oppressive and unfair and bullying, whether, in fact, any of the admissions that Oliver made sense, whether they corresponded with the facts of the case. If I am right in my analysis on any of those points, then the court is entitled to act upon them, whether or not counsel made them. And in fairness to counsel, I think it should be pointed out that the way that we see things today may be very different to the way that they saw them. And may I just mention 3 examples. First of all, the interviewing technique, influenced strongly by the Reed technique. It was, as I well remember, the sort of thing that many police officers went in for. And many lawyers probably accepted, well, this is, and judges as well, well, this is just how police are entitled to interview defendants. The landscape has changed completely. And some counsel would have alleged that they were bullying, questioned the way that they did it, but not all. Now, it would be unprofessional conduct for police to behave in the way to any defendant that these officers behaved towards Oliver, I suggest. The second point I make is that we have gone to some trouble, and of course we've had many years to do this, in fairness to trial counsel, which they didn't have, to look at every document and compare statements and police reports and notes and say point X, point Y, point Z. If they didn't do that, they cannot be criticized. And the third point I would make is in relation to the summing up, where again, it was regarded as proper for judges to make comment favorable to the prosecution, which today would be regarded as misdirections. I put it in that general way. I can elaborate on it if I can. And so all of that puts into context my reasons, A, for conceding that they were not incompetent in any way, and B, for making the rather analytical submissions that I have sought to advance on Oliver's behalf. You were told, my learned friend, that you were bound by the judge's findings on the voir dire. Well, that would be a more powerful point if he had been referred to all of the matters that are in play now in this appeal. But of course, he could not possibly have considered developments in the law which had not occurred by 1991. And perhaps the most important thing is the test for a waiver of the right to a solicitor. Voluntary, fully informed, which did not come into force until 2012. And on that point, please bear in mind what happened at Plaistow, where the defendant was brought into the police station, signed a document that he didn't want a solicitor, taken straight to interview, said the custody record, and within 20 minutes of getting into the police station, he was already being interviewed. Wasn't asked whether he wanted a solicitor at the beginning of the interview. Quite contrary to anything that could conceivably happen today. And again, I ask rhetorically, what is the Crown's answer to our criticisms? For example, do they say that Oliver was not bullied, that the conduct of the police was not oppressive, that they did not mislead him into thinking that there were lots of witnesses against him when in fact there was only one? Do they say that it was appropriate to encourage him to admit to an accidental shooting and that that was a fair thing to do? Do they deny that he was bullied? If any of those submissions is made out on the evidence as you now see it, what is the impact of that upon the grounds of appeal? And the learned friend has said that what was said later shows that the Jackson interview confessions were true. Well, one might have expected to hear some answer to the analysis that they were not true, and in particular the Crown's reaction to the contention that the string holster story must be a complete invention. I repeated that because I was obviously dropping my voice. Thank you. I'm going to ask you if you would rise slightly early. I will tell you why, for two reasons. First of all, because I have to check some notes, and I'm juggling two sets of notes at the moment. But secondly, before you do rise, may I just make a request, and I hope this is not unrealistic. I hope to finish by about 2:30, perhaps a little later. We are hopeful, and if this is unrealistic, so be it, that even if you cannot give reasons today, you will be able to announce a decision on whether the appeal is to be allowed or not by the end of the day, deferring your reasons till later. I'm not asking for an answer to that, but I make the request for very obvious reasons and invite the court to consider it. So on that basis, I hope slightly early, that is a convenient point.
Very good. We'll rise until 2 o'clock and continue then.
Court rise.
Please the court. I move on to the question of falsity, which is now the one criticism made of the experts of the way that they dealt with that. And I respectfully remind the court of an obvious point, that the Crown did not take the elementary step of inviting an expert of their own to comment on the propriety or otherwise of the way that our experts had approached this issue. And I remind you very briefly, and you will have read it, that we had commissioned in September of last year a report from Professor Thomas Peter about that very issue, and he concluded that there was no reason to doubt the professionalism or propriety of the way that Professor Johnson and Dr. Beck had approached their task in compiling their reports. So what we have is the Crown's opinion evidence of what our experts should not have done. They should not have commented on falsity at all. Now, the experts made it plain that they accepted, of course, that this was not a matter for them, that it was ultimately a matter for the jury, and that all they were seeking to do was to draw the attention of the court to matters which are well known to experts as creating a risk of false confession. for example, the vulnerability of the subject or the approach of the officers. So it's the risk that they are looking at. And I could, if it would be helpful, refer the court to 4 authorities. There may be others, but there are 4 that we have found, in which first the House of Lords in Pendleton in 2001, and then the Court of Appeal in 3 later cases, has quoted with approval opinions by experts, sometimes for the prosecution, going to the reliability of the confessions. And so the first one was Pendleton. Perhaps I can give you the references for you to check yourselves if you wish. That is, I'm told by the learned friend, H5-9 at paragraph 21, per Lord Bingham. The second one is King, which is H8-46 to 61. The third is Blackburn, H8-200. And then Nolan and 2006 authority.
Mr. Birnbaum, which paragraph, please, in Blackburn?
Oh, sorry, I should have told you that. Blackburn is at paragraph 29.
Thank you.
Yes. And I'll just read my note of Nolan because it's quite interesting.
So you haven't...
Nolan is...
Hang on.
Sorry.
We're still making a note of your reference to Blackburn.
I'm so sorry.
So tell us the 4th one, please.
Yes. Well, Dr. Shepherd testified as the possibility that because...
No, Mr. Birnbaum.
Sorry, we're misunderstanding one another.
Yes, we are. You have so far given us references to 3 of the 4 cases. You began to give us a reference for a 4th, but you haven't yet given it to us.
I'm sorry, yes.
So tell us which the case is.
I'm rightly corrected. The 4th then is Nolan in 2006, H1 55 to 57, and it appears there that both experts for the defence and the Crown, the defence being Professor Johnson, commented on falsity.
Right.
So I say that the Crown's objection on that specific point is misconceived, having referred to those authorities. I turn now to the Crown case, which I summarize in this way, that the court can derive confidence in the veracity of the admissions made by Oliver to the police, because they tend to be confirmed by the fact that he made admissions to both Mrs. Eldridge and soon after he reached custody to an unnamed doctor. First, I remind you of the evidence of Professor Johnson that it is not unknown for suspects to continue to make confessions, even after which they later repudiate, even after they have ceased to be in the presence of police. The defense theory is, the theory which has gained traction ever since it was first propounded by Thomas Peter in 2001, is that in effect, the most likely explanation for a false confession here is that Oliver confessed as the least bad option. A coerced, compliant, false confession, as I believe it's called by the experts. And we say that this has to be seen in the context that whatever he said to Mrs. Eldridge or later to the medic, he had already said so much that was inconsistent, untrue, or incredible as to undermine any confidence one might have in the veracity of his admissions. And we see that again in Mrs. Eldridge's note of what he said to her at about, I think, 1:20 on the 2nd of December of 1991.
You mean 1990, don't you?
Sorry?
Don't you mean 1990?
It is 1990, yes, thank you. 1991 was the trial. Thank you very much. If you turn, please, to CACD1 1957, you will see the transcript of her handwritten note, which is slightly fuller than the typewritten note that my learned friend referred you to.
Sorry, what was the page reference again?
Yes, CACD1 1957. We put in our submissions because the original, of course, was handwritten.
Right.
Yes. I've told the officers, £30, I've told them about gun. Richard came with foster mum. Why did you say it? Something inside me, that's the passage relied on by my friend. I gave gun back. I can't remember where man lives. Mr. O'Callaghan, duty solicitor, trousers, I know about them, it's the top. We took some money or something. I think I slipped and pulled the trigger. Well, as I pointed out at the last hearing, no money was taken or anything, and the suggestion that he slipped and pulled the trigger makes it very difficult to understand the track of the bullet, which went, you will remember, almost horizontally into the skull. And so that, with somewhat less detail, is what was repeated in the typed note that my learned friend referred you to. And she said, you'll remember, it was not clear whether Oliver was making a confession or telling a story as if in a television program. This needs to be investigated much further. The learned friend questioned whether that might be inadmissible. In my submission, it plainly is admissible for two reasons. First of all, because as Archbold 11-2 comments, a statement of opinion may be given by a witness on a matter not calling for expertise as a compendious means of conveying facts perceived by the witness. And the examples given include the general appearance of the person's state of mind, health, or emotion. And so her comment that it wasn't clear whether he was making a confession or telling a story falls within that category in my submission. And the other possible basis for admissibility is res gestae under the Criminal Justice Act 2003, Section 118, because the statement relates to a physical sensation or a mental state such as intention or emotion. And it is very significant that she, coming fresh to this, was struck by the possibility that he was telling a story as if on the TV. And then we go to the other matter relied upon by my friend, which is the very, very briefly recorded admission to a doctor that both were armed with guns, which, as you may remember, I commented on the last occasion, seems virtually incredible for a relatively minor robbery in an off-license. And our submission, contrary to that of the learned friends, is that the more of these admissions you look at, the more troubling it becomes, because the greater the degree of inconsistency there is amongst the admissions and with the known facts. So I leave that with the court. I turn now briefly to modern standards. And I'm sure that the court will have taken on board our submission, analyzing the cases that we could find, that it is plain it would be putting it too high to say that if you've been tried a long time ago and your incapacities and vulnerabilities were inadequately recognized at the time of your trial, then you can just go to the Court of Appeal and use that as a get-out-of-jail-free card. Of course, you can't. But it is striking that there are a number of cases, and we have found 6, where the court was not satisfied that the conviction was safe because modern standards would have enabled a person who was disadvantaged in a way which perhaps was not appreciated at the time to present his defense in a better way, or indeed to have a solicitor at the time of his interview in some cases. So there is that tie-up, therefore, that important tie-up between the application of modern standards and a subsequently detected vulnerability in the defendant. In relation to one aspect of modern standards, the intermediary, it may be that the mere fact that someone didn't have an intermediary is not enough to render the conviction unsafe. But here we say that looking at what actually happened during the trial, and you may remember I took you through this with some care at the last hearing, it is plain that Oliver was in the witness box for a length of time that would seem to be inordinate and even oppressive by modern standards. He seems to have had few, if any, adjournments during his evidence. He was made, no doubt with the best of intentions by the judge, to read out a passage from a newspaper which he struggled with. He was barely audible at the beginning of his evidence, so much so that the judge had to order a transcript. And he was obviously asked a number of leading questions, putting the prosecution case to him, as was the custom at that time. And so the contrast between the trial that he had today and the trial that he had then and the trial that he would have today is stark. And even if he were not ordered to have an intermediary, special measures would necessarily be put into effect, which would ensure that everything was done to give him the best possible opportunity to put his case forward and to avoid any misunderstanding on the part of the court or on the part of any lawyer engaged in the trial. Finally, and perhaps you should never believe an advocate who uses that word, but I hope finally, I am going to deal with the important question of Samuel's and his repeated exonerations of Oliver. Now, it is very important to remember that we have a huge advantage over those who conducted the trial and the trial judge, because we know of a history which begins with the Harvey admissions and ends with an interview many years later with Miss Cowell, the BBC journalist, in which it is clear that on at least 6 occasions, Samuels exonerated Oliver to various different people, all of whom were independent of one another and who could not have collaborated, still less colluded. And the simple question about that, of course, is why? Why would he do that if one can be sure that Oliver is guilty? But I want to focus on the point made by the learned friend, that in effect he's saying that the only one that matters is the plea of guilty by Samuels. And I suggest that that is a particularly arbitrary submission. The problem is this, and I remind you of the history. Prosecuting counsel were going to do their duty as ministers of justice perfectly properly and fairly. They were going to call everything that Samuels had said to the police, including the Harvey admissions. That was the basis upon which the judge ruled against a severance application from counsel for Campbell. Matters then changed because it seems, and we went through this, that there was an exchange of notes between counsel for Samuels and prosecuting counsel, in which effectively the prosecution agreed that the Harvey admissions might well be inadmissible because they were not obtained under caution and they were not adduced. I think there was an inquiry from the court as to what the reaction of the judge was. We don't know, because we don't know how and when the judge was first told about this, but undoubtedly there was that change.
No, the question was not what was the judge's reaction. The question was, did those representing the appellant at that time make any representations that the way the case was being conducted had become unfair?
We don't know.
Well, have you asked?
I'm sorry?
Have you asked?
That wasn't one of the questions that the court directed us to ask.
No. No,
but we have.
It's not a question of the court directing you to ask questions, Mr. Birnbaum. You are making a submission about the relevance of a course of action which was taken at trial.
Yes.
It is perfectly reasonable for the court to inquire whether at the time anyone thought it was so unfair that a representation or submission should be made about it. Speaking entirely for myself, I would have thought that before you wanted to advance this submission, you would have wanted to check. You haven't, but don't blame the court.
No, I'm sorry, I'm not trying to blame the court. But Lord, your Lordship is perfectly right. It doesn't look as if counsel made any protest about that at all. I accept that. But looking at the case in the round, and considering that subsequently the only statements that we know of by Samuels are statements exonerating Oliver, one can see that even if no one was at fault, the potential for injustice is very great. And what I say is that if there is any possibility that Samuels was telling the truth in exonerating Oliver, and doing so in the Harvey admissions, which were very detailed and very circumstantial, if there is any possibility that that was true, then the trial must have been unfair. And let me make it clear as well that I am saying that that as a matter of fairness and elementary justice, the jury should have known the whole picture. They should have known, as they did, what Samuels was alleged to have said on arrest. They should have known of the Harvey admissions. They should have known of the plea of guilty. They didn't know of the Harvey admissions. I want to deal briefly with an important point the learned friend made when he said, well, the Harvey admissions would not have been admissible in favor of Oliver because they were hearsay at the time. Now, in my submission, although I can understand why he says that, that must be a misconception for this reason. One needs to distinguish between two questions. First of all, who was entitled to adduce the admissions and in what circumstances? And secondly, what would their effect be if admitted? Now, sadly for justice, at the time of the trial, as you know, and indeed at the time of the appeal, Oliver's counsel had no right to adduce those admissions save in one special circumstance. That was if Samuels were to give evidence, if he were cross-examined about the Harvey admissions, and he denied making them, then they could be put to him. And you'll remember, perhaps, that trial counsel made the comment in their note, their observations, that it was a considerable blow to them when Samuels did not give evidence. So, when Samuels did not give evidence, it was a considerable blow to trial defense counsel. But then the question is, supposing that those admissions had been before the jury, what would their relevance be? And this is where I part company with my learned friend for this reason. If you imagine what direction the judge would have given to the jury about Samuel, he would have said, amongst other things, members of the jury, if you are sure that the Harvey admissions are true, sure, then there is a basis for convicting Samuels at least of manslaughter. Well, then how would he direct them about Campbell? Surely he could not say to the jury about Campbell, or members of the jury, although they might prove Samuels' guilt, they're totally irrelevant in considering the case against Campbell. He would surely have to say to them, if you think they may be true, that is the end of the case against Oliver Campbell. Otherwise, it's a recipe for forensic chaos. The jury have to be directed on two quite inconsistent bases, and that could never be allowable. The central problem is not a problem which is the fault of the judge or counsel or any individual of the trial. It is the flaw in the law of evidence that existed at the time that did not permit someone who ought in fairness to have been able to rely on this material to do so. And I mentioned Pendleton before. I remind my lords of a dictum of Lord Bingham, I think it was at paragraph 28, that it is always a matter for considerable concern when a matter of real importance has not been heard by a jury at the trial. Our point is the time for ventilating the truth of the Harvey admissions was at the trial. It could not be done for reasons that are not anybody's fault, and Oliver may well have suffered, because he may well have been an innocent man. That is a further reason why, because the trial was unfair, why the verdict is unsafe. Are there any further matters upon which I can assist the court?
No, thank you very much. We'll just rise briefly.
Court rise.
At the conclusion of the hearing of an appeal, one of three things may happen. If the court feels able to proceed immediately to give a reasoned judgment and thinks it appropriate to do so, then it may. If the court feels able to announce the outcome of the appeal, whilst reserving reasons to be given at a later date, and thinks it appropriate to do so, then it may. If the court feels unable to take either of those two courses, it may simply reserve both its decision and its reasons. All those are matters for the court to decide. It needs no invitation or suggestion from counsel, and it was quite inappropriate for such a step to be taken. In the present case, the court has heard extremely detailed submissions from leading counsel on both sides, occupying 2.5 days. The oral submissions come on top of detailed written submissions. 17 grounds of appeal have been raised. There has been dense argument on most of those individual grounds. It will, we believe, come as no surprise to anyone that the court regards the case as raising difficult and important questions which need careful consideration. For those reasons, we will adjourn now. We will reserve both our decision and our reasons to a later date. We anticipate that in the fullness of time, we will provide to counsel a draft written judgment, invite the assistance of counsel with the correction of typographical errors or obvious errors of fact, such as getting names or dates the wrong way round. We will invite counsel to agree between themselves any consequential matters which may arise, and we will expect to hand down the judgment without the need for any further oral hearing. If circumstances dictate otherwise, we will give directions accordingly. Our thanks then to all who have assisted us in this hearing. Our thanks to the many members of the public who have been, if we may say so, attentive and courteous throughout. Will rise.
Will rise.